What happened with this mapping?
That petition notification. I have challenged, but that matter is listing before the division bench. So motion, I pray for listing that matter and the matters may be taken.
No, the question is the division bench stated the matter will be taken up by the district bench.
We have challenged notification, so that will be.
But if it is being taken up by the division bench, unless the division bench passes the matter, it is not possible.
And if it is allowed to be listed, then I say list this matter along. With the matter.
What is the other resolution number?
Six 2024. 24.
60.
24.
I think 70 of this is allowed. We do one thing. Pass an order for the registry to put up before the changes, saying that this matter is connected with that matter. And the changes will take a decision as to whether you would like to have this matter in the bench with the other matter. These are interconnected. I cannot direct.
No,
We shall order. Sometime maybe. Like connected. Taking the
for further hearing.
8 people option. Made people option.
matter.
What do you mean? Sorry, you cannot have any rejection order. You can teach us how
When I asked to submit a show to the court,
So I have informed the people who have
informed goals out there. The earlier cancellation of the tender can be allowed for.
Okay.
That matter has not been listed. Coming up.
Right, please lost.
Yeah, tell me petition to get the letter.
My lord, I have already informed Mr. Sharma. He will be very possible. Obliged.
We will take you have
2 o'clock, my lord. It was 2:50. Obliged, my lord.
My lord, private vegetable market has been suspended lawsuit. Against that, my lord, petition was filed close to other lawsuit. Against here, my lord, people are suffering lawsuit because market is suspended. Therefore, there lawsuit on the.
Lordship, but with regards to item number 1 to 10, your lordship, you file a record, you have to call for your lordship. That we call for it in opposition for the department. Have you filed? Yes, we filed the document. Yes. Always.
May I pray for an unlisted motion today, Your Lordship?
What is the urgency?
Lordship, tomorrow is the last day when the penalty will be imposed upon us.
Penalty for what?
Penalty for non-delivery of cylinder on time.
And your problem with the ERBC.
No, no, not that matter, not that matter. Another problem. Different matter, the same party lordship, but different broker.
Only yes, I mean,
Lord. Understood.
I
Understood.
did to be.
Third.
Okay, we'll take it.
We are allowed to withdraw this petition matter, and we are allowed to withdraw this petition matter. We can revert to second.
What liberty? Liberty is the way dangerous thing.
But whatever in this case matter,
Why a liberty is different? What's the case?
after filing the application matter, a subsequent development has taken place.
Take when you see them, let the decibel be a military,
Okay. Then thereafter, my license was suspended.
Now what do you want?
I may be allowed to withdraw my lot with a liberty of
Why? Why do you want to withdraw? Which is the-
all this facts, my lord, record to important to record.
Lordship, that license which was cancelled, Lordship, there was another petition that was disposed of yesterday, Lordship, by coordinate bench of this on the report, wherein, Lordship, the appeal was, there was the appellate authority, Lordship. So they were directed to dispose of the appeal which was pending within 30 days. So with that direction,
The
that,
challenge to the cancellation.
yes, Lordship, cancellation
So
of
what we mean
this-
about the suspension?
Lordship, this
It is
is sealing of the pharmacy.
My pharmacy was still.
No, unless your you can get it like that. Something is pursuant to a cancellation.
No, my lord.
Initial suspension and then cancellation.
First, Lordship, it was sealed. Lordship, the pharmacy was sealed at first, and then thereafter, Lordship, the license was
So unless you have the license, you cannot have this case. You will be seized.
What are by defined of
But the owner of the pharmacy is who?
and the owner of the premises,
You are also a pharmacist.
lordship. And
You can obviously run the pharmacy with some other pharmacy.
lordship, my staff was there, my lord, he injected in my lord, my staff was there, my helper was there in the pharmacy, my lord. In my absence, my lord, he injected my lord anti-rabies vaccine to my lord child, my lord. And subsequently, my lord child was died, my lord.
I understood, it is understood. My question is, the ceiling you want to withdraw, the liberty to borrow, to get hold of any other pharmacies, you can run the firm. Then
can run the, but first this will have to be on paper.
it's the cable, the cable, Bolwa.
Borua.
Legal counsel appearing on behalf of the petitioner submits that the petitioner would like to withdraw the instant petition with the liberty to reply. The legal counsel appearing on behalf of the petitioner submits that in the meantime, pursuant to the scheme of the pharmacy which is challenged in the instant proceedings, the license of the petitioner as the pharmacist was cancelled. And the same was, and the same cancellation was challenged in another proceedings. Petition. Read proceedings.
Yes, I can give them.
Being the petition number
2020 of 2026. 2020 of 2026.
the learned council further submits that the learned court that bench was disposed by the order dating locality. Disposed of the state distribution with a direction to the appellate authority to dispose of the accused within a period of 30 days. He therefore submits that in the circumstance the accused is allowed, the petitioner should be given the liberty to revive the prayer by filing a separate petition. It's the so Commander, the learned Commander, the learned council appears on behalf of the health and family welfare department. taking into account the submissions made by the learned counsel assuming on behalf of the petitioner. The instant petition stands closed on word, and the petitioner is also granted the liberty to reply in the circumstance. The petitioner's license, the cancellation of the petitioner's license, certified. Or should I also mention that, or the petitioner has also been is able to get hold of another premises? Subject to the petitioner's license, permissive license is the cancellation of the petitioner's permissive license is satisfied, and or the petitioner is in a position to engage another licensed premises. Look. Okay. Yes, what is this case? Lord, the workman was dismissed by after holding an inquiry. The workman was dismissed. The chart we will find. The chart is under, my lord, the standing order 10 A Roman 2. But then punishment has been given under charge 10 Roman 1. My lord, which cannot be under any circumstance. Now, apart from that, if I take your lordships to the chart at page 16. What is your ground? Ground, my lord, I was holding that land for long, 60 years back. That has been supported by MW Port, that is the Lat Mandal. He says that I have been in possession. Now they are saying that I have been in a illegal position and I am, they have given me notice that to vacate their land. The land belongs to whom? Land belongs to, they say it is the land of the tea state. And you say? But I am saying I am holding that I am having possessory right and I have improved the certificate. That has been. From where? Whose right? Whose land? Where our thing that it is not the land of the tea state. Huh? It is not the land of the tea state. And my forefathers were been in possession of that land. So you say that it is not the land of the of the petitioner tea state. For the tea, of the tea state. Yes, it is not their land. Okay. Nonetheless, one thing your lordship will find. Now, supposing they say they have given a notice to evict me. No such notice your lordship will find. Even the MW1, he is the manager of the tea state. He has said I did not issue any notice in any point of time. Now, if I take your lordship to it, the evidence of the MW1, entire thing will be clear. No, evidence of one notice. No, there is a crack because when he is saying there was no notice issued, then how come the question of the attraction of this clause 10A of Roman 1, that is willful subordination. Lordship, when you see the charge sheet at page 16. Page 16, page 16, 1-6. I'm ready. Your lordship has seen 10A2 of the standing order. Now, the standing order your lordship will find it is there in the report. You don't say out here that the land is not that of the owner of the estate. In your reply. Reply. Finally come to paragraph page number 18. 18. First paragraph. He's saying the land had first been in possession my mother, and after him I have been in possession for over 60 years. Position, as I have understood, means using and utilizing a plot of land under physical actual position, and for which I have possession certificate number so and so so and so, issued by the circle officer, the brewer, and land revenue receipt showing that he is paying the revenue also. Meaning thereby, my lord, this is the land not belongs to the estate. Huh? You have not denied. That is not, that is, therefore it is the land of the estate. Now, supposing it's the land of the estate, you know, can this, whether it will attract standing order clause 10, A1 or A2? My lord, your lordship will find the charge on 10(2), that is theft, fraud, or dishonesty in connection with the company's business or property. So whether the land can be, where is the standing order? There in the last of it, one standing order there, or in the record also. It is document number 10. Then Roman 2, my lord. There's the charge. Huh? Theft, Roman 2. No, the charge is on not on 10A Roman 2. My lord, 10 is 10 small a Roman 2. Okay. Should have been Roman 2, but there dispute arises regarding the subsistence allowance payable to a workman under demand. And employed concern may refer the dispute to the labor court constituted. This is a standing order for what? Standing order for the standing order for tea state. It's not tea state. Yes. Now tell me where it is. Lordship, where is the misconduct? And now your lordship can see the chart. This is pending for year. It is 10 small a they have mentioned. They must be mentioning some other standing order. Small A2, Roman 2. 10 capital A. No, small. In the standing order. This is the industrial employment standing order. It's a different thing. It is marked as document number 10. Okay. Standing orders for tea states in Assam, the membership of the Assam and we have values of Indian. Right. That's the thing. Then Roman 2, that's the charge. Now, Roman 2, you'll also find theft, fraud, or dishonesty in connection with the company's business or property. Now, by no stretch of imagination, it can be said that the land can be come within the ambit of theft or fraud. And the punishment you will also find willful, there is 10A Roman 1. Willful insubordination or disobedience, whether alone or in combination. Now, whether it can be done that way. Charge is in some. The charge is on willful insubordination. Charge is on no theft for. You also can see 10A Roman. This you cannot say this because there is no Roman 2. Roman 2. No, where in the standing order. Mr. Dotto, kindly come to page 16. There is no Roman 2. Well, yes, they have done a mistake there. So they have made a mistake here. So it will come under 10A. So anybody, 10A. Why you are choosing to Roman 2 and the numerical 2? So that will not something here, not will find a case of insubordination in the disciplinary inquiry.
and all that.
Not satisfied with that. Next ground,
And now this is the ground. Now
this is your only ground.
the ground. And now if it is the insubordination, my lord, where is the insubordination?
You have been
When-
asked to leave. We have not adhered to, you are occupying the state land
No, my lord, when
merely because of the possession certificate. You are admitting. You are not denying that the land does not belong to the petitioner, the state, the state.
denial is not there.
What?
We are saying that we have been in possession of that land.
What?
Wrong certificate.
For that, you have to file a suit.
No, that's the thing, my lord. Now, your lordship kindly see what MW1 has stated. He said that no point of time they have issued any notice to us. If it is so, then my lord, how insubordination comes? Can I read that, my lord, the evidence of?
Let's see your revenue receipt, exhibit A. The domestic inquiry.
The lordship come to page 43 of the award. What MW1 has stated, the lordship find that.
Here you see the exhibits which you have enclosed. Kindly come to exhibit A of your exhibit 1. Evidence of Workman witness number 1. Kindly come to that document, exhibit 3. What is the ground? Let us see. Ground is okay. The careful putting of the whether the case will be now, the moment the issue number 3 has been decided properly, issue number 3 pertains to the domestic inquiry having been held properly by the AR. unless you show there is perversity in issue number 3, why should I enter into other aspects? The question would be, in a similar factual background, the appeals court is saying, when the charge has been framed in a particular area, you cannot go beyond that and go punishment to some other crime. So exactly on that, but if the effect could say, you can very well go to the effect court for this again. My question is here, unless and until the decision in respect to the issue number 3 is said to be bad, or you say to be perverse, and convince this more, why should I go into other aspects? Because once the fairness of the inquiry has been upheld, then as per the clear, it is not even required to go into the merits. That's good thing. That fairness itself is in question. That fairness itself is in question. That has been said. That has been upheld by the EIA at page 56. Yes, he said it. But then the question would be, where is the eviction notice to me? It's a denial notice given. I have been following the land. No, that is a different thing. Whether they evict you as per whatever the proceedings they do, it's a different thing. But the fact as regards the fairness of the inquiry, if it is held to be proper, then obviously this court would not have the jurisdiction on the 226. Even the labor court would not have the jurisdiction. That is the perspective of things. But then in these things, what happens? The charge is something. Punishment is something. Where is the evidence? The question of insubordination, where is the evidence? There is no evidence at all. Even MW1 he himself is saying, I did not issue any notice for this person. He has said himself. But if I read the cross exemption, here it has been categorically mentioned out there. In the truth above, I therefore call upon you to explain so and so as to here. In your reply, did you say that you are not going to do it? I sincerely candidly admit I have done nothing wrong. Whatever I have done is done on the strength of the valid documents obtained and possessed, and as such, I in no way deserve the notice served. Explanation sought, serious surges, level, hasty suspension, etc. seems to be a mere conspiracy against me. So therefore, you categorically deny. You have not also mentioned that you have not understood the charge. You have also not mentioned in your reply to that effect that the charge has not been properly explained. I don't understand 10(2)(a). How can there be a question of theft, which you are now trying to build out there? This is not your case. Let us see your written statement. You take that plea. Can I take your lordship to page 43? What the MW has said, that has been stated here. 43, paragraph 19. Page 40, 43, paragraph 19. Yeah. Let us see the evidence. Evidence as standard by the management report. No, Mr. Dutta, I'm not going to enter into all this. First, you have to convince me as regards fairness of the inquiry. Well, unless issue number 3 is decided in your favor, I need not enter into other aspects. Make it very clear. In order to clarify all that. No, you have to show me where. Let us read issue number 3, the discussion in respect to issue number 3. Kindly come to page 53. Yes. There is no dispute regarding the holding of a domestic inquiry against the workman. As per the evidence of Iman, the workman had that he fully participated in the air wherein he cross-examined some of the management witnesses. I've carefully gone through the inquiry proceeding, which is order sheet number, and also read the so-and-so. It appears that inquiry examined as many as 3 management witnesses and 2 workmen in presence of 2 independent so-and-so. Exhibit A, I have found the inquiry report past recorded day-to-day orders so-and-so. The order sheet contains data-wise. The MDA has exhibited all her orders in the so-and-so. Thus, it is clear the inquiry duly maintained and recorded all important happening in the case in hand, it is evident from the domestic inquiry conducted against the workman relating to the charges so and so. There is no allegation of victimization as well as allegation against the management that it had not acted in good faith. It appears that the case of the workman is that the domestic is not fair on the ground that all proceedings were recorded in English language, which is not acquainted by the workman, and the inquiry officer did not consider the aspect of long possession over the disputed land by the workman. In this respect, the inquiry officer clearly stated in the year that he narrated the whole happenings of proceedings in Assamese language to the Imam, who clearly understood and thereby raised no objection. Regarding the long possession of the inquiry, stated the workman could not produce any document before the proceeding. As such, she rejected the contention of so and so. That the inquiry so and so mentioned in the inquiry report that the workman pleaded guilty at times of alleged charge read over to him in the proceedings, and also considering the other material evidence on record, the workman committed the alleged acts on the charge memo and so and so. The workman was charged with disobeying the order of the management not to enforce upon so and so and directed him to vacate the land by demolishing so and so. The nature of jurisdiction is that when vacating a while so management has the right to discipline so and so, in my opinion. So no, I think it's there.
Now, your lordship, kindly see paragraph 39, your lordship, kindly see. Workman was charged with disobeying the order of the management not to encroach upon the tea state land and directed him to vacate the land. And these directions, your lordship, will never find in this proceeding.
Right?
There is no
There, in fact, the answer is there in your written the reply itself. In your so-called reply also, you say that earlier, when you asked me that I have explained it to the welfare officer. That's your reply.
The first question is they are saying that directed him to vacate. What is that order or letter? I did not find in the proceeding. And MW1 has supported that. He did not issue any point.
Only to come to your explanation, you at page on 1/12/2006.
Page 17.
That on 22, you see the so-called notice was issued on 16/11/2026, 2006. Okay, 6/11, 16/11. That on so and so, I personally met the welfare officer Matak and intimated that I would submit my explanation on so and so, to which he acquiesced, and in fact, I did submit my reply. Explanation in writing to your notice dated so and so on the same date, but unfortunately, my personal copy was not signed as a proof of receipt. It therefore cannot be imposed upon that I failed and I have not. That as for the second paragraph of your notice, I cannot but express that I feel highly pleased that I have been offered a second time opportunity to explain by 7 a.m. on so and so, despite my written explanation there. The terms to explain contained in paragraph 3 of the Iman, and the terms not submitting any explanation in so and so are unintelligible, in the sense that I have failed to understand so and gave my verbal explanation. And in such a case, having not no such time, I have no alternative but to intimate the year who actually. But however, I keep with the statement made in so and so, I'm happy to explain why to construct a house, Kacha house on the land in question. The fact is that the land at first has been possessed by my father, and after that, and after him, I have been in possession for over 60 years. Possession, as I have understood, means using and utilizing a plot of land under physical actual possession, for which I have a possession certificate showing so and so. That in view of the above, the contents of paragraph 4 of the RIA stating that the charges leveled against you are serious and are unfounded, irrelevant, baseless, and impactful, and as such, the act of suspending me from my duty does not arise. We come to the evidence of PW1. MW1. That is, we'll also look at cross-examination part. MW1, Toilendra Kumar Goswami. Paragraph 3, paragraph 4. I state herein, paragraph 5, I state herein that by notice stated so and so, the management of so and so issued a general notice to all workmen, sub-staff, and all employees of Matak Tea State not to occupy or encroach company land illegally, nor to transfer any person, any land of the company after coming into illegal occupation by committing illegal encroachment or any other manner, was duly hanged in the garden notice and in other conspicuous places. In spite of such notice, the delinquent illegally occupied a plot of land measuring so and so. On receiving information, the delinquent constructed a kacha house on the aforesaid so and so. Welfare officer to the and sent welfare officer so and so to the place of occurrence to verify the report. Accordingly, Ms. So and so made a spot verification, consulted relevant document, and reported to the management about the illegal construction of a kacha house by the delinquent unauthorizedly in the company land. Therefore, the workman was called to the office. The welfare officer asked him to vacate the land immediately by dismantling and removing the kacha house. The workman refused to obey the reasonable orders of his superior. The manager of the garden also called the delinquent aidman. The manager directed the workman to remove the illegal construction. This time also, the workman did not obey the orders of his superior. Thus, the delinquent committed gross misconduct under 10A1 and 10A2 of the standing orders for the tea state in Assam in the membership of the Assam and Suma Valley so and so so and so. The workman committed dishonesty in connection with the company's property by encroaching upon and constructing a house on the company's land. Now let's see his cross which was done. Yes, cross of that particular person. Yes. My affidavit in lieu of the examiner, I have joined the Mata Conference. Since then, I have been serving there. I have no any knowledge in respect of Mata prior to Iman. Initially, the garden was owned by Jokai. Thereafter, the same garden brought under the management of MP so and so so and so. Not a fact that I had been occupying the disputed land prior to my joining. It is not a fact that the father of the workman, namely so and so, had occupied the disputed land. It is not a fact that after the death of the workman, father, the workman had occupied. I have issued a certified certificate. Not a fact that since the time of my previous management, the workman has been occupying here in not for the first time I have objected. A general notification was hanged on the office board prohibiting the staff employees for not occupying the land of Matak State. I have not given any written notice to AR in this regard. I have seen the land revenue paying receipt of so and so since 2001 to the year, but it is not concerned to the disputed land of dark number 136. It is not a fact that the workman has not occupied the land for many years. I did not issue any official notice to the workman to vacate the land. I have not filed any suit for the disputed land in the civil court. There are so and so land, so and so, and there are approximately. I have filed 6 cases under the land grabbing for a plot of land measuring 15 bighas of land. Out of that plot, 4 bighas is occupied by Lawal College, which is under our previous management. Those portion donated by the previous management. Here in the cross, you say I have no right to occupy any portion of the land covered by grant 27 of the 148. Your certificate of possession is on that. You categorically say in your cross-examination that you did not, nobody constructed, your son constructed it, and the son has been residing over that land.
Yes, in fact, son is constructible.
That is your, the cross, although your affidavit says otherwise, that your forefather had constructed.
Those discrepancies are there. And now, Melody Lordship, can we see? General notice means what? Your Lordship will find that in page 21.
I think we dismiss it.
You know, this what I case for disposal. I'll take your Lordship once again to the the MW1 cross examination.
Huh? Cross off?
Examination of the MW1.
Yes, what did
I'll
it?
just try to pursue it also. I have a certificate hearing number so and so dated 12/3/2000, certifying that that the land on the periodic patta number so and so occupied by the workman Javatta since 1960. Now, if I take a worship to the general
Wait. You are saying about the cross-examination of?
cross-examination of MW1. I have a certificate from there.
Where, in which portion? I have a certificate bearing number so and so certified
The land.
that the land under periodic patta number is occupied by the workman since 1960.
1960.
So,
Now, in the context of this, if I take your lordship to page 21 of the writ petition, just for a file, your lordship, see that it's a general notice dated 2/11/2006. I'll just read you. There's been noted that serious concern that some of the workers of motor tea state have been indulging in acts subversive of discipline in that land within the tea state grant has been passed on for occupation to unauthorized persons, resulting in enforcement of garden land. In the recent past, workers have been warned of such illegal activity, but no attention has been paid to the management's reasonable plea. It is being notified that if such activities carry on, strict disciplinary action as well as appropriate legal measures should be adopted to house the encroachers. It is also being notified that any worker involved in such illegal and subversive activity would be liable for termination from services with dismissal. Non-workers who are involved in such activities would be reported against the necessary steps to be taken against them as per the law of the land. Therefore, expected that all workers, residents will initiate action to protect the state. Now, this notice say that these person with the workmen have been in position since the last 60 years. So if there is no specific notice that MW1 has.
we never raised that issue. We are in 226. We have never raised that issue there.
And take a look further in the cross-examination. I have not given any written notice to the Jagattasa in
Yes.
this regard. Now, if it is so,
No, it was given to all.
this is a general notice.
And there is not even a cross-examination to that fact where in his evidence on chief, he categorically mentions out there that this particular workman was asked by the welfare officer went there to his place and found that he was constructing a kacha house. Thereupon he asked him not to do so. Thereupon that particular the workman was asked by the manager to come to his office. He came and he was specifically told there is not a single cross on that aspect.
But then question would be, you're saying that the question of insubordination comes. In that case, what will happen? Is there any written notice to? It's a general notice.
So-
And general notice is not applicable in my case
Why?
because I have been.
No, for your eviction, you may have a very good case. That's a different case. But for any worker out there saying that don't occupy any of this land or construct anything out there, that is enough.
Now, whether it affects, the clause 10, because clause 10, what they're saying? They're saying on acting on 10A, Roman 2.
No, where do you get Roman 2?
Roman 2, ten is what, because the inquiry report also says so, here also.
Nowhere it is said Roman 2. If you see the cross, the chief of MW1
Then 10 is.
and the cross of and the cross of MW1, that is your specific, you have put up under question also there. When you put a question, it will be meaning that you have understood that you are charged under 10A Roman 1 and 10A Roman 2. Well, you see, this is the cross.
But then you also can.
That is
Chart will have to be very specific.
no,
If the chart is
no,
there.
no portion of the
At page 16 once again.
dismissed.
No,
But you have
that's a different issue. Let me
not satisfied.
let me
not
clarify
satisfied.
the matter.
You see,
Can you
no, Mr. Doctor, the question is like this. 226 jurisdiction in respect to a labor court is when there is a question of perversity. There's no perversity.
But even at the cost of that, my lord, I want to submit
No perversity.
that above if proved are offenses under 10A2. If
Where?
10A2 means what? Chart means
So
that
then you should have said that. I have not understood the charge. Where is it? You have been saying about you have categorically replied out that even in your domestic inquiry also you have not mentioned that you have not understood the charge.
But then chart will have to
You have
be
been all
specific.
along understood.
Is the chart specific here? And your lordship kindly see.
You are occupying into the government's land, the estate's land.
No, your lordship kindly see. This is the chart and finding is what at page 57. Just for a while. The workman in not vacating the land in which the house was constructed thereon has disobeyed the direction of the management which amounts to misconduct. Now they're saying on that is clause 10A Roman 1. If the charge is on Roman 2, how the punishment?
Why
will be
did you
Roman
put
1?
that question in your cross? On the other hand, you put a question on cross that it either has to be 10A1 or 10A2. And when this particular person management witness number 1 categorically mentioned in its sheet that he is being charged on the 10A1 and 10A2.
Now in the similar circumstances, I'll take your lordship to a decision of the appeals court. Squarely the factually covers case law. And rely on my lord 1963 SCC online Supreme Court page 97. Yeah. Lord, I'll read from para 2 and on. We shall deal first with the case of Manik Chandra Das, which appears on October 23, 1959, he was served with a notice in which it was alleged that a number of articles had been spoiled due to his faults. He was asked to show up within 48 hours of the receipt of the notice why the company should not take disciplinary measures against him. In his reply of October 25, he denied any responsibility in the matter. He mentioned that he had reported to the supervisor and Sardar's about the defective articles beforehand, and according to the advice given by them, had painted borders. According to the management, an inquiry was held against one on October 29, 1959. And on the report of the inquiry officer, the works manager, he was dismissed. The order of dismissal was made on 11/11/1959. In this, it was stated that he had been dismissed from service of the company for causing willful insubordination or disobedience, whether alone or in combination with another or others, of any orders of the supervisor or the manager. It appeared that some evidence was laid before the industrial tribunal against money to show that he had caused some damage to the company's property. The tribunal held that the rules of natural justice were not been allowed to the tribunal. It then examined the evidence adduced by the witnesses on behalf of the management and came to the conclusion that there was no sufficient material before the tribunal
to hold that money was guilty of insubordination or disobedience for which the dismissal order purported to have been passed. The tribunal further pointed out that the evidence before it in respect of the alleged damage done to the company's property was not sufficient for stagnation in charge which might merit dismissal. In support of the appeal against the order, Mr. Shanmugha has urged that it was not open to the industrial tribunal to go behind the finding arrived by the domestic tribunal. To contend with the absolute finding. Then my lordship, see para 5. There is again the curious circumstance that while the domestic tribunal recommended the dismissal of money for a charge of having deliberate false damage to raw materials of the order of dismissal passed by the management was not in respect of the misconduct. Order in terms mentioned that we were dismissed from the service of the company for causing willful subordination or disobedience, whether alone or in the combination with another or others of any of the superior of the management. It appears that the charge sheet which was sent to money from so-and-so did not mention any charge of willful insubordination or disobedience. Exactly here we go. There is no charge of insubordination, willful insubordination. Only charge was, to theft, defraud, dishonesty of the company's property. Now, when there is no charge of insubordination, how the punishment can be imposed on them?
In the domestic inquiry report, therein found that there is no case of insubordination.
Now, insubordination, here there is also no
No,
insubordination.
here they have found it in the case of misconduct, domestic inquiry.
But then, there is no letter of the management, the MW1 himself saying, I did not issue any eviction order to him. On the basis of that, these things is in parameter on facts as well as on punishment.
Recent past workers that the bond of 3 days to. Yes, Mr. Das.
First
Let
of
us
all,
hear to put your arguments also while dismissing the.
Well,
And let you support the case of.
well, they are kindly, well, the charge against the
These
petitioner.
basic cases
Lordship.
that you see in the charge sheet. You have mentioned that you have will be found guilty of clause 10A bracket numerical. And as such, 10A bracket numerical 2 or Roman 2. There is no numerical 2, but Roman 2 would mean that it is a case of theft and not a case of insubordination. So when you have charged him not with theft and not with insubordination, can you dismiss him on a charge which had not been made in the charge?
But in fact, the charge.
Mr. Dotto, that is your submission.
But in fact, the charge against the petitioner is not the broad charge. The charge against the petitioner is that on 12/11/2006, he constructed a Kacha house in Dongalguri line without prior discussion, permission of the management. And it has been clearly stated that that by general notice dated 2nd of November 2006 issued to all workers of the garden regarding encroachment of company's land. That cannot be done. That is the charge. Well, the broad charge is that he has, in violation of the company's general notice, he has illegally constructed a house over company's land. And he has in detail explained to the charge. The foundational facts are that, and on those foundational facts, he has replied to the charges. It is not a case that he did not understand the charge. What the management is alleging against him. So, in that case, if the submission, if going by the submission, the decision which the petitioner has relied and the submission made by on behalf of the petitioner, it will be a case of prejudice. That I am prejudiced because I don't know the charge.
to what I would respond. This is not a case at all, because the broad charge is that you have violated the general notice and you have encroached upon the company's land and you have constructed a house illegally in violation of that. That is the charge. And he explained that that land belongs to me, my family. He said, but it is not true. In fact, the entire contention is that the officer went to your place, found that you have constructed a new house. In fact, in his evidence, he said that this house is constructed because of his own use. It is admitted petition, my lord. It is not a case that he did not understand the charge, he did not get the opportunity to reply. Lordship will in a case, in a given case, lordship will interfere, may interfere in a case where charges will have, suppose charge is misappropriation and ultimately the finding is recorded on the insubordination or something. Here is a case 10, the standing order 10 says these are the acts that will amount to misconduct. Ultimately, my lord, the charge is that you have constructed a house over company's land, and that is the foundational facts. And on the foundational facts, he has replied. Entire departmental inquiry, entire the proceeding, evidences have been laid, cross-examinations, witnesses, evidences, everything has been on that basis. So there is no question that he did not get the opportunity to explain his conduct, or he did not understand what is the allegation against him. So that argument will not come in this case.
What do you say about once the domestic inquiry is updated?
Well, the domestic
All
inquiry,
stipulated, I know, the domestic inquiry is upheld. Then there is no requirement of going further.
well, that is the settled position, my lord. That is the settled position. Lordship will interfere only when perversity is there in the inquiry.
No, the industrial tribunal will do the merits only if the domestic inquiry is found to be wrong.
Found to be wrong. Yes.
Maybe a person who is working in a particular company, it is an internal matter of the company.
Absolutely, my lord. Absolutely.
And for that, they have a domestic inquiry. Therefore, they don't use the word department. They use the domestic.
Yes, my lord. Yes.
Once it is a domestic inquiry, it is only to be seen as regards the fairness of the domestic.
Whether the inquiry has been properly conducted or
Now,
not.
if the domestic inquiry has been fair,
Yes.
the next question is as to whether the punishment is disproportionate.
Punishment, proportionate and disproportionate, that is
another question.
that is
That
another
is
question.
another question as regards that.
The-
That is not the question which is being urged by the
No,
petitioner.
not at all.
It was a second sort of
True, true. Well, the tribunal as well as this honorable court, ultimately the tribunal at the first instance has seen that the petitioner was fairly provided the opportunity of hearing, cross-examination, evidences were there. Ultimately, the inquiry proves his guilt. And the foundational fact is one and the same. Whatever terms it is used. But I would humbly submit that on same foundational facts, he replied to that, he responded to that. So the inquiry was found to be fair by the tribunal. Now it is before the honorable court. There is no perversity in the order. There is no perversity in the order by the tribunal. So my
And it is only on the face of perversity this court can interfere.
absolutely, this totally interfere, not otherwise. So a fair opportunity was given to him, and the findings recorded by the inquiry officer, in fact, I would humbly submit that those are not beyond the charge. The charge is broadly charges that he has constructed illegally a house on company's land in violation of the notice.
His written statement, in the written statement, he says that his father constructed the house. But in his cross, he says that his son has constructed.
Rather, the evidences are there, Malad.
And the petitioner's wife resides in the house.
No.
Whereas in his cross, he says no.
It is
They reside in the quarter.
it is for his son and lot of and in fact the evidences shows Malad that he has the land which he is urging to be his family for 60 years. That is not particular, that particular land. That is a different plot of land altogether.
And in his written statement, he says that the charges leveled against the petitioner is baseless and irrelevant, as the petitioner had never encroached the company's land.
So encroachment over company's land, illegal construction of a house over company's land is a charge. And that is the foundational fact to which he has replied. Mal. Mal. Other.
Heard Mr. Ezapto, the learned senior counsel, appearing on behalf of the petitioner assisted by so and so. Mr. Dina appears on behalf of the respondent number 1. And Mr. Doctor, why do you make the presiding officer a party? This is being always deprecated, looked down upon, everything.
But then 1966 Supreme Court is saying, if say statutory jurisdiction is there, then record is required to be called. Even without that. Also,
And the Supreme Court has categorically saying, making a judicial officer a party is also strongly reprimanded, deprecated in all strongest of the words.
But then, I can tell your lordship, the way we are making them party, last when your lordship asks us to make them, it's okay. But then sometimes.
In fact, it is my feeling is this is a matter which should have been taken under 227, not 226, because
There is a
the authority is because the Supreme Court judgment wherein it says that the court exercises supervisory jurisdiction. Because this is a judicial order. This is not, although it is a quasi-tribunal, quasi-judicial tribunal, but it is an order passed by a judicial officer.
We are making party only because of.
Don't make parties. Not to make them.
But then 63 Supreme Court has said otherwise.
Where?
And I think
19? There are many Supreme Court judgments later on.
But then the similar strength of the judges.
Why we,
Because
in
of
respect to labor disputes, why do we go back to 1960s?
Anyway,
And close our eyes there.
we don't want to take the blame because supposing we don't include.
Unless you allege malafide, it's a different thing. You can, but you have to put it in by name.
Against the court, we cannot.
Number 2 level.
No, only
Appears on behalf
only
of-
one submission. That if that submission has to be made, petitioner has to show the prejudice caused. No prejudice has been alleged, not state. So ultimately the SK Sharma judgment is there that ultimately the real prejudice the petitioner has to show before lordship. If that argument is to be accepted by the petitioner.
Which argument?
The charges are different.
No.
Logic. Logic.
Nowadays I've stopped relying upon the referring to judgments. I do it by reference. The division bench helps all these judgments to be. So and so appears for the respondent number 1. This court strikes out the respondent number 2 from the array of parties. In as much as the respondent number 2, in as much as it is well settled that when an authority exercises judicial powers, the said authority ought not to have been made a party in the proceedings. In fact, the Supreme Court in various judgments have also deprecated arraying the presiding officers of the tribunals as parties to the proceedings. The brief facts, the instant petition has been filed by the petitioner challenging the award dated 6/10/2017, passed in reference case number 1/2015 by the learned industrial tribunal of Assam at Dibrugarh. for short, the learned tribunal, whereby the reference was answered whereby the application filed by the petitioner was dismissed. Application filed by the petitioner under section 2A, capital A of the Industrial Disputes Act 1947 was dismissed. Holding inter alia that the petitioner is not entitled to be reinstated in service with full back wages, nor any other consequential benefit. And further opining that the petitioner would be entitled to get all benefits due to him from the date of the joining in his service till the date of dismissal as per the rules of the state. The question arises in the instant proceedings as to whether this court, in exercise of the powers under Article 2 to 6 of the Constitution, should interfere with the award, impugn award. Next, the brief facts which led to the filing of the instant proceedings are on 2006, the petitioner P-State, through its manager, the respondent P-State, the management of the respondent P-State, issued a notice informing all concerned that some of the workers of Mutok P-State have been indulging in acts subversive of discipline in that land within the T-State grant. And have been passed on for occupation to unauthorized persons, resulting in encroachment of garden lands. It is further mentioned that in the recent past, the workers have been warned of such illegal activity, but no attention has been paid to the management's reasonable pleas. It was further mentioned that if such activities carry on, strict disciplinary action as well as appropriate legal measures will be adopted to oust the encroachers. Further to that, it was notified that any worker involved in such illegal and subversive activity would be liable for termination from service. Pursuant thereto, a notice was issued to the petitioner on 16/11/2006, alleging that on 12/11/2006, the petitioner had constructed a kacha house in Bangloguri line without any prior discussion of the permission from the management. It was further mentioned that in the general notice dated 2/11/2006, it was clearly stated to all workers of the garden regarding encroachment of the company's land. It is further mentioned that if the charges against the petitioner, that is, inverted comma, that is, that the petitioner on 12/11/2006 had constructed a kacha house in Bangalore line without any prior discussion of the permission from the management, and in clear violation to the general notice dated 2/11/2006. If proved, would be offense under clause 10, small a, numerical 2 of the standing orders in force on the state. The petitioner was asked to explain by 18/11/2006 at 8 a.m. why disciplinary action should not be taken against the petitioner. The record reveals that the petitioner thereupon submitted an explanation to the said communication dated 16/11/2006. And in the said communication, it was mentioned that the petitioner admitted petitioner stated that the land had been first in possession of his father and after him, upon him, for over 60 years. And the petitioner have been using and utilizing the said plot of land under physical actual possession, for which a possession certificate was issued on 12/3/2000 by the Circle Officer East/West, Dibrugarh, and land revenue receipt showing revenue thereof was paid up to 2006/7. The petitioner therefore stated that what the petitioner have done is done on the strength of valid document issued, obtained and possessed. And as such, the petitioner do not deserve the notice served and the serious charges leveled against the petitioner were nothing but a mere conspiracy against an innocent person like the petitioner. The petitioner also sought for a personal hearing. The records further reveal that the management being dissatisfied with the petitioner's reply constituted a domestic inquiry to inquire into the charges which were leveled upon the petitioner. The inquiry report of the inquiry report of the inquiry officer had been exhibited before the Learned Industrial Tribunal as Exhibit A7. From a perusal of the said inquiry report, it is apparent that the charge against the petitioner, that is, inverted comma, on 12/11/2006, the workman has constructed a kacha house at Bangla Guri, Bunglawguri, line unauthorizedly, when the management issued a general notice on 2/11/2006 to all garden workers not to encroach any company's property, company's land, inverted comma, was read to the petitioner and explained with other documents to the petitioner in Assamese. It is fair to see that upon reading the charges and explained to the petitioner had pleaded guilty to the charges by submitting his written reply. Be that as it may, the inquiry officer conducted the inquiry by examining the witnesses on behalf of the management as well as the workman, bracket petitioner, and thereupon opined after a factual adjudication that the management was able to establish the charges as mentioned in the charge sheet against the workman beyond all reasonable doubt. It was further mentioned in the said inquiry report that the petitioner was guilty of the work charges as leveled against him, which amounted to gross misconduct as per the standing orders imposed on the estate. Upon the said inquiry report being submitted by the inquiry officer on 31/1/2007, the petitioner was issued a show cause notice on 13/2/2007 enclosing the inquiry report and asking the petitioner to show cause within 7 days. No. Before the management could take a final decision regarding the petitioner's case. It was further mentioned that in the event of no representation being submitted, it shall be presumed that the petitioner had no representation to submit and the management would dispose of the case in a manner deemed appropriate. The petitioner thereupon, by the communication dated 27/2/2007, sought for 1 month's time and thereby granted an extension to the petitioner up to 9/3/2007 by the communication dated 27/2/2007 for submission of the inquiry, submission of the representation. In spite of those opportunities being granted, the petitioner did not submit the representation. Rather, on 9/3/2007, the petitioner again sought for further time. The management, by then another communication dated 12/3/2007, provided the petitioner another 3 days to submit the representation and further intimating that there shall be no further extension of time. The petitioner thereupon submitted some reply on 14/3/2007. And the management of the respondent state, after duly considering the same, decided to dismiss the petitioner from service of the company with effect from 1/4/2007 by the communication dated 31/3/2007. Petitioner thereupon filed an application under Section 2, capital A of the Industrial Disputes Act 1947, for short, the Act of 1947. The learned tribunal after the learned tribunal, the records of the reference on the basis of such application filed by the petitioner, a reference case was registered, being reference case number 1/2015. Both the parties were provided opportunity to file their respective pleadings as well as adduce evidence. By the impugned judgment and order, by the impugned award dated 6/10/2017. The reference case number 1/2015 was dismissed. Thereby upholding the decision of the respondent management of dismissing the decision of the respondent, thereby upholding the decision of dismissal of the petitioner by the respondent management. It is under such circumstances the present petition has been filed. Mr. S. Dotto, the learned counsel appearing on behalf of the petitioner, submitted that the entire proceedings, which was initiated on the basis of the so-called notice dated 16/11/2006, was defective in as much as the so-called notice which was issued was vague. The learned senior counsel submitted that in the so-called notice dated 16/11/2006, there was a mention that if the allegations are proved, it would be an offense under clause 10 small a 2 of the standing orders imposed on the estate. The learned senior counsel submitted that the standing orders which are applicable are the standing orders for the tea state in Assam in the membership of the Assam and Surma Valley branches of the Indian Tea Association. And in terms with the said standing orders, there is no clause 10A numerical 2, but rather there is a clause being clause 10A Roman 2. And a perusal of the said clause would show that the allegation would be theft, fraud, or dishonesty in connection with the company's business or property. The learned senior counsel therefore submitted that the allegation which is made in paragraph number 2 of the so-called notice dated 16/11/2006 under no circumstances can be said to be a misconduct in terms with section clause 10 small a bracket Roman 2 of the standing orders. In that regard, the learned counsel, senior counsel appearing on behalf of the petitioner, appearing on behalf of the petitioners, have referred to a judgment of the Supreme Court in the case of Tool and Enamel and Stamping Works Limited versus Workman, reported in AIR 1963 SC 1914, and submitted that the allegations submitted that the facts of the said case are similar to the facts of the instant case, in as much as in the said case, which was pending before the Supreme Court, the charge was in respect to deliberately causing damage to the raw materials. Whereas the ground on which the workman therein was dismissed was on the ground of willful insubordination. The learned senior counsel therefore submitted that in the instant case, a perusal of the charge shows that the petitioner have encroached upon some land of the petitioner of the respondent state, respondent management of the respondent, the state. And on the other ground, the action which was sought to be taken was in terms with clause 10 small a Roman 2, which pertains to theft, dishonesty, and dishonesty, fraud in connection with the company's business or property. The learned senior counsel further submitted that the perusal of the evidence on record would show that the management witness number 1, upon being cross-examined, had categorically admitted that the petitioner was not issued any notice for eviction. And therefore, without issuance of such notice of eviction, how the allegation of willful insubordination to the actions of the respondent management can be said to have been proved. This aspect was of vital significance, which the learned industrial tribunal failed to take into consideration, and thereby have rendered the decision of the impugned award perverse. Anything more? Mr. Dinat, the learned counsel, appearing on behalf of the respondent number 1, per contra, has submitted that the allegations so made submitted that the notice dated 2/11/2006, thereby directing all workers not to encroach upon the respondent state's property or carry out any illegal activities of transferring, was a prelude to the show cause notice dated 16/11/2006. In spite of the said notice dated 2/11/2006, the petitioner on 12/11/2006 started construction of a kacha house in the Bangalore line without any prior discussion or permission from the management. The same constituted a misconduct. The learned counsel, appearing on behalf of the respondent, further submitted that it has never been the case of the petitioner that the petitioner have not understood the charge which has been leveled against the petitioner. Rather, at the time in the initiation of the domestic inquiry, when the petitioner was read the charge, the petitioner had pleaded guilty. The learned counsel, further appearing on behalf of the respondent, state further submitted that it is an admitted case of the petitioner in his cross-examination that the construction was not made by his grandfather. Rather, the construction was carried out by his son, which vindicates the stand taken by the respondent management. The learned counsel, appearing on behalf of the respondent, further submitted that on one hand, the petitioner had mentioned that the petitioner as well as his father was in occupation of a particular plot of land. There is no denial to the fact, there is no denial by the petitioner to the fact that the respondent management is the owner of the land. And this aspect would be apparent from a very perusal of the cross-examination of the petitioner, wherein he duly admits that the land in respect to which the certificate has been issued belongs to the respondent state. First, the learned counsel appearing on behalf of the respondent number one further submits that there is no necessity for this court even to discuss on the question of merit, inasmuch as the fairness of the domestic inquiry has been upheld, as would be seen from the impugned award dated so and so, wherein the issue number 3, which pertains to the fairness of the domestic inquiry, have been discussed, and there is no perversity in such discussion in the opinion rendered by the Learned Industrial Tribunal. The Learned Counsel further submits that it is a settled principle of law that in respect to the internal affairs of a particular company, the court would not in the affairs of the particular company, more particularly as regards the discipline, the interference by the court in respect to the domestic inquiry held would be only in the case when there is a violation to the principles of natural justice or there is any perversity in respect to such decision. The Learned Counsel submitted that the Learned Industrial Tribunal have duly considered all these aspects and found there to be neither a case of perversity nor a case of violation of the principles of natural justice. And as such, the question of interference with the impugned award may not be made by this court in exercise of the powers under Article 2 to 6 of the Constitution. Anything more? Can I attend some of the? Yes. I have heard the Learned Counsel appearing on behalf of the party and have perused the materials on report, the respective pleading, as well as the report of reference case number 1 of the 15. First contentions were raised by the petitioner that the Shoko's notice was effective inasmuch as the allegations were made were not clear. Appears to be an afterthought. Inasmuch as the petitioner have never raised such an issue as regards never raised an issue in the entire proceedings, right from the time of submission of the reply to the Shoko's notice till the decisions were rendered by the Learned Industrial Tribunal in reference case number 1 of the 15 as regards the defective as that the allegations were made against the petitioner were not clear, for which the petitioner was prejudiced. It is further relevant to take note of that on 2/11/2006, there was a specific notice issued by the management This notice have been exhibited as Exhibit 9 before the learned labor court. A perusal of the said Exhibit 9, which is dated 2nd of November 2006, makes it clear that the management of the respondent state have informed all workers involved in activities involved in indulging in any act of discipline, subversive act, subversive of discipline in have informed all workers that any worker involved in illegal and subversive activity of occupation or passing on for occupation to unauthorized persons, resulting in encroachment of garden lands, strict disciplinary actions would be taken and would result in termination of service. In spite of the said notice, which was issued on 2/11/2006, on 12/11/2006, it came to light that the petitioner had constructed a kacha house in Bangloguri line without any prior discussion of the permission from the management, which was in conflict with the general notice dated 2/11/2006. This aspect was informed to the petitioner by the communication by the so-called notice dated 16/11/2006 as to why action should not be taken against the petitioner for constructing a kacha house on 12/11/2006 over the land of the petition respondent company. The petitioner, in the same notice, it was also mentioned that if the offense which is alleged is proved, it would constitute an offense under clause 10A Roman 2 of the standing orders. It is pertinent to mention that a perusal of the standing orders would show that as regards gross misconduct, what clause 10A stipulates what amounts to gross misconduct. There is no numerical number 2 as a subclause. However, there are Roman there are various subclauses from Roman 1 to Roman 12 of clause 10A, which would constitute a gross misconduct. The petitioner, at the time of submission of the reply, did not mention that there was any vagueness in the allegation so made in the so-called reply, so-called notice dated 16/11/2006. Rather, it was the specific case of the petitioner that the land which the petitioner was possessing and had constructed a house was a land which has been under the occupation of the petitioner as well as his father for the last 60 years. And this was shown to have been, the petitioner based his case on the basis of certain documents issued by the circle officer of Distributor East of the West Revenue Circle. The reports further revealed that the reply so submitted by the petitioner was not found where the charge sheet is what? Sixteen. No, kindly come to this document. One document. There is another charge sheet of 2311.
2311 is the 2311 he filed a reply. When 2006 one.
It will appear that thereupon on 22/12/2006, the management of the respondent state, having not found the explanation given by the petitioner to be correct, to be proper, decided to hold an inquiry into the charges against the petitioner. And the petitioner was informed by the communication dated 22/12/2006 that one Srimati A. Sharma of Tinsukya have been appointed as the inquiry officer, and the petitioner was asked to report on 25/12/2006 at 9:30 a.m. in the office to attend the inquiry proceedings. This aspect will be evident from Exhibit 11 to the inquiry proceedings. The record reveals that on behalf of the petitioner, the record reveals that the charge against the petitioner was read over by the inquiry officer. And the petitioner pleaded guilty. The petitioner then also did not mention that there was any vagueness in the allegations in the show cause notice. Rather, the petitioner had pleaded guilty. This court have also perused the written statement filed by the petitioner, the applications were filed by the petitioner. Before the learned tribunal under section 2A of the Act of 1947. A perusal of the said application would further show that there is not a single statement made that the petitioner, that the so-called notice dated 16/11/2006, 16/11/2006 was defective, or the contents of the said show-cause notice were vague, or which had prejudiced the petitioner in submitting his reply. This court have also perused the evidence which have been adduced by the petitioner before the learned industrial tribunal, wherein also there is not a single statement made in the evidence of the affidavit to the effect that the petitioner was prejudiced on account of the vagueness in the show cause notice dated 16/11/2006. Considering the above, it is therefore the opinion of the court that the first contention made by the learned senior counsel appearing on behalf of the petitioner appears to be an afterthought, merely on the ground that it is mentioned that if the allegations are proved, then it would constitute to be an offense under clause 10A bracket Roman 2, numerical 2 of the standing orders. In that view of the matter, the first contention so made by the learned senior counsel stands rejected. The second aspect, the second contention so raised by the learned counsel appearing on behalf of the petitioner, is on the question of perversity in the impugned award, inasmuch as it is the contention of the learned senior counsel that the petitioner, having not been issued a notice to vacate, the petitioner cannot be imposed that no disciplinary proceedings can be initiated against the petitioner. On this aspect, the learned senior counsel have referred to the evidence of the management witness number 1, wherein the management witness number 1 had stated that he had not issued any written notice to the petitioner during his cross-examination. This court have duly considered the said aspect And in the opinion of this court, that the said submission is also misconceived, in as much as a general notice was issued on 2/11/2006 to all workers not to encroach upon the lands of the respondent state or carry out any such illegal activities. In spite of that, it was also mentioned that if any of the workers were found to be indulging in such activities, strict disciplinary actions would be taken, which would result in termination of employment. The petitioner knew about the said. There's no denial to the fact that the said notice, general notice, that 2/11/2006 was issued by the petitioner. It is further said that on 16/11/2006, the allegation which was made was that on 12/11/2006, the petitioner was constructing a kacha house on the company's land. In spite of there being a general notice dated 2/11/2006. Under such circumstances, the findings were arrived at by the learned inquiry officer, as well as the learned industrial tribunal, coming to a fact that the petitioner had committed a misconduct in terms which clause 10A of the standing orders do not appear to be perverse. Rather, it is the opinion of the court that the opinion of the learned inquiry officer, as well as the learned industrial tribunal, is in consonance with the evidence which has been produced before the authorities, before the learned inquiry officer, as well as the learned industrial tribunal. Under such circumstances, this court at this stage finds it relevant to take note of the judgment of the Supreme Court in the case of Central Research so-and-so versus Bikartan Das, reported in so-and-so, wherein the Supreme Court categorically observes that the exercise of a writ in the nature of certiorari can only be made when the order passed by the inferior tribunal is perverse or based upon materials and is perverse, suffers from perversity. As no perversity could be shown by the petitioner in the impugned award dated so-and-so, passed by the learned tribunal, industrial tribunal, it is the opinion of this court that no question of interference, the opinion of this court, that the question of interference with the impugned award does not arise. Accordingly, the instant with petition stands dismissed. The registry shall return the reports to the learned tribunal, the industrial tribunal. There shall be no order as requested.
Please, also, the PTC being the enforcing authority, they took the land of the petitioner for the purpose of setting up Kendriya Vidyalaya. Now, afterward, in 2021 even,
Yes.
now, when they have admitted in their affidavit, about the existence of the the property which they have taken care of, and apart from this, the rate was also determined by the government agency. Lordship, just look, it is their own admission in certain extent that affidavit in opposition filed by respond number 2, paragraph 8, page 128. Page 128, affidavit in opposition filed by the respond number 2,
para 8.
Then
Now, Lordship, page 139, Annex 1. In 2021, the price of that, my lord, that has also been fixed by the authority concerned.
but where is the agreement?
But agreement was not executed because, my lord, we have insisted for execution of the lease agreement. We have insisted for lease agreement, but their correspondent itself said that they have taken the position and price was also fixed. Page 139, Lordship, page 139,
39,
139, 139.
139, I'm ready.
Yes, my lord, that Lordship has certified
They
that
only pick the rate.
from the period 22/8/2009.
Now who is to pay?
My lord, this has to be paid by the BTC, my lord, since they are the sponsoring authority. And my lord, it is their duty.
So we are not the sponsoring authority with the humble submission, Lordship, because
Because the Tennessee sponsoring authority says in page 146, my lord, page 144, my lord. The whole story is there. Last paragraph, sponsoring authority. And my lord, the page
Wait, wait, wait.
146.
Yes, why haven't you filed an affidavit?
Lordship, because the lease, Lordship will come to the writ petition once, Lordship, at page 30, Lordship. The writ petition, 30, Lordship. The writ petition.
Yes.
Lordship, this is the uh, lease agreement between Manoj Kumar Bajaj and Kendra Vidyalaya Sangha Thane, Lordship. Now, in
Has
the
there been a lease agreement? No.
Well, it is a draft part will be submitted. That was never executed. Now, lordship, only one line is very important. Page 146.
Wait,
144.
one person say.
Sorry, let it.
So my humble submission is that, yes, the land and revenue is a transfer subject, Lordship. However, Lordship, I have not found any document which says that the BDC principal secretary is the sponsoring authority in this case, Lordship. Because the DC Udalguri had issued the letter of consent.
Then
Moreover, Lordship, Lordship takes up the affidavit filed by the respondent number 326, Your Lordship. There is the KV. And more particularly at page, Lordship, 102, Lordship.
where the affidavit of response?
326, Your Lordship, at page number 102.
102. No.
Yes, Lordship. The end, Lordship, signature of the sponsoring authority, Lordship, Deputy Commissioner Udalguri.
Who is responsible? Page
102, Lordship.
no. This is the
Affidavit.
Filed by the.
this is a document made the terms and conditions for opening of a Indian Vidyalaya under the civil sector of the defense sector. Are there?
Lordship, yes, sir. At the last, at 102, Lordship, the signature of the sponsoring authority, Deputy Commissioner Udalguri.
What would they people say? Who is paying for responsible 3 to 6?
Well, BTC even not file any affidavit, 7 and 8.
UTC doesn't want to file everybody in opposition. What to do? You've given them the opportunity.
Yes, sir. And last occasion, they admitted that they have no role to play by the order dated. That was
Yes.
recorded.
Lordship. If I may,
21/1/2026.
if I may submit, Lordship, the affidavit which has been filed with the respondent number 2, I was also not privy to the contents of that. It's the first time I'm seeing it. We have not been served a copy of that.
Huh?
We have not been served a copy of the affidavit which has been filed with the respondent number 2, implicating us as the sponsoring authority, Lordship. As my learned friend has pointed out, page 146. In fact, I'm seeing the page number 146 for the first time today. We have not served a copy of this affidavit,
By the respond number 2.
Lordship.
Why haven't you done it?
And 11.
So you don't want the KVS. You don't want the KVS. Is the KVS functioning?
No, agent they have vacated because new construction was already made by that BTC. Now it can be shifted.
Then,
Now, so far,
then why after 9 years? you have
thing is
to-
that in 2021, we have because that the period was going on in between discussion, etc.
Where are your representations asking for money earlier?
Yes, 2021, that.
2021. It was taken in 2008.
Reason is that prior to that, the correspondence which is going on, that about the
Where is
fixation,
the correspondence?
my correspondence is,
Where is the correspondence from your side?
thing is that, because rate was not fixed, that's why they have responded in
The
2020.
rate was not fixed. You should not have given without the fixing your rate.
Lordship 2020,
What is the report?
no, Lordship 2021, Lordship, can you see for a moment? No, Lordship, just look for a moment.
Not satisfied.
Can you see? No, Lordship, just look for a moment.
Not satisfied.
Page 139, madam. Based on my representation, after,
139, take that advantage from that. I'm not concerned with all those documents. My question is, if it was taken in the year 2008 or 9,
madam,
which you claim
Madam.
that it was taken in 2008 or 9, with effect on 2008-2009, if it was taken. Then in that regard, why were you sleeping till 2021?
yes.
107 months. Why?
Well, see, prior to that, my lord, it is a clear picture that the position was taken care of by the BTC, and after that, can they be the level set
Now,
up?
why were you
No,
sleeping?
my lord, we have, it is their duty, my lord, if the file will call for,
Oh,
my lord.
your duty without the.
No, absolutely, my lord, kindly see, my lord,
This is the case of
my lord, contractual obligation also cast upon them also, my lord.
section 70. Who did? Contractual obligation is 70.
My lord. Now, kindly see, my lord, that one thing is that, my lord,
Why
that-
should this not fix
my
anyway?
lord, kindly call for their file, my lord, that will reveal that, that whatever thing, my lord.
Where is a single document from you?
Yes.
All these.
Lord, my lord, it is true that, my lord, prior to 2020,
No, no,
don't have the
please,
discount. But, my lord, 2008, my
Not
lord,
satisfied.
that limitation runs, my lord, lordship, kindly see.
Not satisfied.
My lord, limitation runs from 2021, my lord, because it is their admission 2021, 2022, 2024, we have served them in legal notice, my lord. That was also not responded from their part, my lord. Therefore, my lord, kindly see that limitation
When did they vacate?
in 2025, my lord, last part. The last part of 2025, December, my lord.
So they vacated.
Yes, my lord, because that new construction was made, permanent construction, therefore it was shifted there, my lord.
So then why were you not doing anything? There was no agreement from 2008 onwards.
My lord, even they have, my lord, handed over the property to us by virtue of, my lord, giving a letter to us that now we want to vacate that property in 2025. It is not a dispute about the, my lord, position, etc. Only thing is that, my lordship, put a question on limitation. Now, lordship, limitation is such, my lord, 2009, the position was taken care of. Now, my lord, we have insisted that, my lord, sometimes.
When did you?
Well, can you see, my lord, papers, my lord,
When
sometimes-
did you insist? My question is, when did you insist?
Lordship, just call for a file, my lord.
No,
Just
why-
quickly file to DC, my lord.
Not satisfied.
But
This is not the case. I've made a mistake in issuing some notice.
No,
What
Lordship,
do you say, Miss Udas? Yes. No correspondence.
no, Lordship,
We dismiss it. I should not have issued.
no, Lordship,
notice.
two things can be done.
Became more encouraged by the notice I issued on 6.
My proposal is this, if Lordship gives some time, then we'll collect the papers of their file by giving RTI that what postponement they have made prior to date, my lord, then we'll submit in the affidavit, my lord.
Your document you have.
And actually, sometimes for
Not
what
satisfied.
the party is not in that position to pose the earlier documents, my lord, but it is a fact, the file poses.
Art Mr.
Sometimes
S.
we get-
Kamaria, the learned counsel appearing on behalf of the petitioner. Mr. N.R. Sharma appears on behalf of the PTC. Ms. So-and-so appears on behalf of the respondent number 326. Ms. Udas appears on behalf of the district administration. The petitioner herein. The petitioner has filed the instant with petition claiming an amount of rupees 3 crores 21,57,695 as the lease rent for the period from 22/8/2009. So, admittedly, there has been no lease agreement entered into by the petitioner with any of the authorities. So, the records further reveal that on one hand, the records further reveal that there appears to be a confusion as to who is the sponsoring authority, in as much as in a particular document which have been enclosed as annexure annexure Roman 2 to the affidavit filed by the respondent number 326. The deputy commissioner has signed the said document as the sponsoring authority. On the other hand, the deputy commissioner, Udalguri, has written a letter to the Principal Secretary, Boroland Territorial Council on 24/5/2022, wherein it is mentioned that the PTC should look into the matter related to lease agreement as sponsoring authority. It is also very pertinent to take note of that though the petitioner claims that since the year 2009, the land of the petitioner and land along with the building of the petitioner was taken for the purpose of using it as a Kendriya Vidyalaya. But there is no records which should show that the petitioner ever claimed any of the dues or insisted on filing of the written statement or insisted on entering into an agreement with the respondent number, with the concerned respondent authorities. Till 2001, till 2021. The same aspect appeared, as we mentioned,
Page 146.
At paragraph 9 of the affidavit in opposition filed by respondent number 326. The case of a petitioner, at best, may be a case, prima facie appears to be a case of claiming certain contractual dues on the basis of Section 70 of the Indian Contract Act 1872. Under such circumstances, this court is of the opinion that before entering into the question of merits, the maintainability of the writ petition has to be looked into. Or for that matter, as to whether this court should entertain the instant dispute. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that he would be filing an additional affidavit in that regard, indicating the correspondence between the petitioner as well as with the other authorities in respect during the period from 2009 to 2021. List this matter when?
After 4 weeks, my lord.
List this matter again on 3rd of August 2026. In the meantime, the affidavit in additional affidavit be filed by the petitioner. Oh, this matter.
Scrapping.
Where they is not qualified the essential, mandatory essential condition.
I know, I know. Then, who is appearing for you? Mr. Ding here, you are there. Let's see, because I am tied up at two. It's very rapid, there are lots of them. Let's see how the forest matters goes, and thereafter see whether to pick up the matter. The issue is only, it's a simple issue pertaining to some clause not being followed, if that document is not there. So I will use it to execute. This is Annexure 7, the land council hearing submitted that there will be this very document will show that only the manufacturer has put the signature and there is not a single signature of the respondent of the file. We therefore completely understand that the MOU could have been taken into consideration by the respondent. That's your long and short.
The issue of maintainability was also first order, what you were indicated.
On the ground that there was earlier a repetition that.
On merits that has been dismissed. So whether in connection with the same tender process, same allotment of the award, they can come up with new points.
There has to be a closure order to.
They've not taken order to route to B. But I'll satisfy your lordship whether exception 4 will apply, section 10, exception 4 will apply. Ground of attack. The ground of attack was not written by knowledge. It is the admitted fact in the affidavit that these documents were not available for any of the prospective bidders to see after submission as well as after.
Then it's a case of review. Would it be a case of a fresh petition? Because there will be no ending.
That
Just for example, today you take one point, again you take another point. You keep on taking point, one point. And now, that day, a very interesting document which came up on the question of not on this aspect, but I was saying about the very recent judgment, I think by Justice Anjeria, NB Anjeria to that effect.
as regard order to route to.
No. Order to rule to, you will obviously make the submission taking into account the judgment of our bench. I think that's this. Well, I suppose. wherein he categorically says that the order to rule 2 would not be applicable with proceedings. So that is, I know you make the submission, therefore I'm not going to insist on that. But my question is, that was the case of where recent judgment on the issue pertaining to complaint. What should be the date which should be taken into consideration? Is it the date of filing of the complaint or the date on which the cognizance is to be taken? Now, there was a Supreme Court Constitution bench of judgment of the Supreme Court wherein it says it is the date of the filing of the complaint which is to be taken. Now, the question arose before the Supreme Court was that certain issues were not being looked into at that point of time. Now, the question, therefore, is it necessary for disturbing the judgment on the ground in any other case, on the ground that this particular issue was not raised, not taken? If it was not taken, it has to have a closure. The order to rule 2 may not apply, but the principle of order to rule 2 can be very well incorporated.
Well, we have said constructive.
Constructive utility, the lordship knowledge is important. The might and ought implies knowledge. I should have knowledge. And it is, they have not denied my statement that I have come to know about this facts only after the contract has been signed. So I could not have taken this ground of attack in my previous one. Because
But wouldn't it come a case of review?
That is,
Because then they will, again, you don't find out again another, just for example, a very flimsy, here you have a very good reason, let us. If we start entertaining, keep on entertaining repetitions after repetition, you can keep on filing on flimsy grounds also. You can. How does it stop it then?
because
You may have a very good reason here. You didn't know. Many things you may come to light or may not come to light. Now, the fact that at that point of time, the documents ought to have been placed, have been looked into, or the financial documents or whatever the documents, the technical bid was open in your presence.
it was published online in the previous week or not.
Now, was it required to be published, open in your presence?
It was published online. And what we had challenged that time is not the selection criteria. We had said the number 1 was not reflected as MSME. Since I was L3 and reflected MSME, I come to the zone of consideration. He should not get all the
Understood. My question is the technical bid. This is a case of technical bid.
technical.
So this technical bid which was there at that point of time was to be open at that point of time. Maybe not have been properly opened.
This was public.
No, was it required to publish everything?
No.
So at that point of time, why didn't you exercise your right to ask for the document then?
They have the policy is that I'll show from their own affidavit. Their policy is that they would not show it to any bidders, and they will, and taking that plea and pretext, now we are suffering. Because it ought to have been transparent. But they have published a
So if it ought to have been transparent, why didn't you raise that issue then? My question is that.
but we have got this document now.
And you will get some more documents after I dismiss your petition today. You may get some more documents. Let us examine. Then what happens? Another petition.
It is because of the ONGC's own actions, Your Worship. This cause of action is not same. Document satisfied the cause of actions is not identical.
Hello, we wait when the matter reaches after my argument.
Yes.
Yes, Mr. Goswami, what are you doing?
This is a
Lordship,
next-
before the night, sorry, I'm wrong time to mention. I'm
Don't
taking the
mention.
liberty.
I don't hear. And that to senior
Yes.
counseling mentioning I don't allow in my court.
No,
Don't
no, I
mention.
was just wondering one thing, Lordship. Is it possible
No,
that
no,
item 23 be taken up today?
Rejected, Mr.
Very good.
these cases, we have filed in 7 cases. We have filed in 7 cases. 3 has come, my lord, rest 4 are in the process, my lord. And because of that, my lord, there was some trace mapping survey was done, my lord, with the help of Survey of India. My lord. That's why some delay. So we have filed. It's ready in, my lord. It's available in the recording item 2, 6, and 8. At Annexure A, my lord, we have completed, my lord, the general methodology in the part by which we have done it. Page 552. Report on item 2. Report on survey, detection, and boundary verification. What procedure, my lord, we have adopted? It's a accepted procedure throughout the country, my lord. Let me read, my lord, preamble and purpose of the report. This report is submitted by the Forest Department, Government of Assam, to place on record in a consolidated form the methodology adopted for survey, digitization, and boundary verification of reserve forest within the state, and the specific factual findings arrived at in respect of Doyang Reserve Forest and Nambur South Reserve Forest, two contiguous reserve forests situated within the Golaka Forest Division. The exercise has been undertaken in furtherance of the directions of the Honorable Supreme Court of India and Honorable High Court, Honorable Gauhati High Court, for eviction of enclosures from forest land, with reference to the judgment dated 10/2026 of the Honorable Supreme Court in Abdul Khalek and others, mentioned. The database so created assists the department in management, monitoring, and protection of reserve forest, in detection of encroachment, and in placing before the court a specifically spatially accurate factual position in ongoing petition. The report is divided into 2 parts. Part 1 sets the general methodology followed in surveying and digitizing the reserve forest of Assam. This methodology has been deployed in accordance with technical best practices and on lines consistent with the procedure already considered and accepted by the Honorable Court in analogous forest boundary verification exercises. Part 2 applies that methodology jointly to Doyang Reserve Forest and Nambur South Reserve Forest, which adjoin each other, share natural boundary features, and have been surveyed as a single contiguous block. The records the findings, including the identification of petitioner sites that fall in the notified boundary of one or the other of the reserve forest. So first part is my methodology. Second part is concerned specifically to this forest. So we have elaborately explained what is the methodology followed. Next page, just to indicate my overview. The methodology consists of 2 logically consistent stages. The first stage is documentation based. The original gazette notification constituting the reserve forest is read together with historical georeference survey of India.
So you say you have done it in this manner. You have an original map. And in terms of the original map, there you have then taken satellite data.
Yes.
Then those images super imposed proportion map and found out actual.
Because my lord, earlier notifications were schedules were, my lord, like in north, there was no longitude and latitude. It was normal schedule, like there is a river, there is a forest, sorry.
Because this gives an equation to expect to around 2 meters. Well, thank you.
Yeah. So by doing that, my lord, we could figure out these maps, my lord. This time, my lord, if my lord peruses the map on 567. This is, my lord, numbers of arrest map. And this green line is the, my lord, boundary of the forest. And this blue dot,
See, this is the numbers of
my lord. This is the map of the reserve forest. This, my lord, blue indicates, my lord, the location of the petition. The blue inside the map, there are some indicates the location of the petition. Remember, go to next map, man.
The longitude and latitude.
Yes, sir. There is the map showing us as well. It is in a house located inside Doyang. There is also my lord is saying. It's blue dots, man. Right?
It is the
Doyang man. Doyang airport.
big numbers of 560.
There's 568 is my lord inside Doyang village first.
You also have to.
Yes, this blue indicates my lord. Right. Right inside.
Where is the doing?
Blue my lord. Middle of the right inside.
Where is the forest? What's found?
568 is my lord. Written at the top my lord inside Doyang. At the heading my lord. Top.
See the state.
Rangma is the right hand side. It's a different forest. My lord.
Why you go to the right hand side?
Yes, this purple color is the map my lord of Doyang arrest. Rangma falls the right hand side.
It's a bigger.
Yes.
Okay. What is the
Well, yes, then Bamboo Doyang arrest 40 for the reason.
the forest? The forest. Oh, yeah.
My lord.
That is small filings.
Yes, yes.
These are the petitions.
These are the petitions.
These are part of the.
Doyang and Nambor. Then page 569 also. Next page. At the right hand side. Inside Doyang. Green is the boundary man.
This is for which is the forest.
Doyang.
Now, we have also another matter pertaining to Workman.
Look, my.
It's not yet.
There, there. But there are three forests, my lord. Lutumari, Lutumai, Nambor Doyang, and one Borpani. So, my lord, we have by this filing, my lord, we have covered all the forests, but not all the cases. My lord. We have to file 7 affidavits, my lord.
No, it's okay.
3 we are filing,
But fact is, you have carried out an exercise
my lord.
by which you have found the petitioner within the latitude and longitude.
Exactly.
Now, the latitude and longitude which you have found out is based upon scientific data.
Exactly.
of that particular machine.
Yes, ma'am.
And this machine will be superimposed upon that particular notification and you find those persons.
Yes.
Now, the only thing which is required, this is by which you give an explanation how you have the longitude.
Yeah.
And the petitioners are found to be.
Yes, ma'am.
So therefore, we can very well pass an order to respect to those cases. Wherein the petitioners say that they are outside the reserve. That there shall be no encroachment in respect to the longitude and latitude of these. Which
Yes.
you have found out on the basis
Yes.
of the map.
Yes.
If the petitioners are inside,
Yes.
they
That
have
is.
to be out. If the petitioners are out.
Yes.
Don't do it. So you carry out your exercise on the basis of the eviction exercise, on the basis of.
This
the
mapping.
longitude, the latitude, you are
Yes.
so that therefore the petitioner is wrong. But this is as regards those petitions wherein the petitioners have stated that they are outside the reserve forest.
Yes.
So that is how it takes care of. Now, as regards, so you have identified the longitudes and
Latitude.
the, so within this, the petitioners cannot be doing.
Yes.
They are petitioners are outside these now. There in these lands.
Yes.
If it's outside the longitude,
Yes.
then
Yes.
obviously the petition you cannot disturb.
Yes.
I think. Secondly, as regards the second issue is as regards the another.
Residing inside under Tongia system.
Now, this is the second issue.
Yes.
Now, how do you address that issue?
That might not
And apart from that, another issue is that pertaining to your affidavit which you have filed before the Supreme Court, wherein in the Supreme Court you say that Assam is a different space change by type of affidavit was filed because otherwise the first observation. Because of it, this is your stand which is was before the Supreme Court and you have to do it. Now you see out there that there are Assam has a different manner things with the reserve forest by which you have certain village
inside.
village forests. And in these village forests, they are you have certain Jamabandi. And in these Jamabandi, the mention of the
Names of
the petitioners or the persons out there, their names are being registered inside in the Jamabandi. Now, how do you take care of that thing? Just for example, because you have this is a reserve forest. Now, if those persons have Jamabandi, their names are there in one of the places you say that they include one of the affidavits, I could find out that there is nothing mentioned. You say that there is nothing, there is no Jamabandi out there in this particular forest. So they will see. But on the other hand, Mr. Liwa had showed us that you see that this is the particular village and these are issues with the village. Now, in respect to if within the Doyang Reserve Forest, or in the Nambo Reserve Forest, or in the Lukmai Reserve Forest, you have the forest village.
No. As regards these cases are concerned, there is no forest village. There is a reference of forest village in a Panchayat notification, which has no application whatsoever in forest land. Secondly, my lord, knows my lord, Forest Conservation Act, my lord, specifically, my lord, that their claim that
But back to me, you have categorically.
before the Honorable Supreme Court. Yes, there are villages, my lord. There are.
Let us see the judgment in the case of.
Yes. Page 269, man.
Now kindly come to page 279.
My lord.
This is the paragraph 3 to 9 of the additional affidavit filed before the Supreme Court
Yes.
in mentioned. Kindly come to paragraph 7. Paragraph 6, 5 onwards.
That if the notice is found to be in unauthorized occupation of a reserve forest area after scrutinizing the documents placed by him, a speaking order is passed and served upon him, giving him 15 days notice to vacate the unauthorized occupation. It is only thereafter that the actions are taken to remove the unauthorized occupation. That so far as the controversy concerning existence of some Gau Panchayat is concerned, it is submitted that there can be a Gau Panchayat in a forest area. This is provided for in section 5 of the Assam Panchayat Act, that is quoted my lord. The state government may by notification declare any local area comprising a revenue village or a group of village or a forest village or tea garden or hamlets forming part of revenue village or forest village or tea garden area or other sub-administrative unit or part thereof to be a Gau Panchayat with population of its territory not less than 6,000 and more than 10,000. That the concept of a forest village is a unique concept in Assam, a person entitled to stay.
Now, before going further, in 1980, you have the Forest Conservation Act. Section 2 makes it very clear that you cannot use the forest for any other purpose.
Yes.
That's a central act. Then by way of a state act, that is the Assam Panchayat
Yes.
Act,
Cannot
which is in
provide.
the year 1994.
Okay.
Can there be a development? Can there be an establishment of a forest with Gaon Panchayat?
No, no, madam. That is where I'm coming, madam. Forest Conservation Act says to the exclusion of all laws of a statement. Section 2.
Exclusion of any law. Now, I'm saying about the law, wouldn't this be in violation to or conflict with the Assam Panchayat Act, particularly Section 5? Wouldn't it be in
Cannot
conflict
survive,
with
Yes.
unless Section 5 emanates from Chapter 9 of the Constitution? Yes, Mr. Chaudhary, what are you waiting for? I've seen proof. Nowadays, we have a lot of new senior advocates, so now we may address you as very senior advocates. Yes. Motion. Okay, we do one thing. Let us take up the motion for some motion and finish it up, and then we take it up one. Okay. You just find out from chapter
Yes.
9 as to whether it is only the Constitution which can say
Yes,
this section 5.
yes. Exactly.
Otherwise, if the Constitution permits, that's a different thing. Otherwise, section 5
contrary
of
to-
the Assam Panchayat Act is in conflict with the
Forest Conservation.
forest
Yes.
conservation.
In fact, on that account, there is a judgment of the Honorable Supreme Single Judge, my lord, which was available at Honorable Division Bench. More importantly, my lord, there is a forest management rule that itself says, forest village management rule, pre-independence law, my lord, that itself says it is non-inheritable right.
Mr. Ken Chaudhary nowadays is doing a lot of matters of one gas agency. This is the third of the petition. Huh?
Yes. Milord will kindly come to page 26, Milord. No, sorry, page number 29. And the operative portion is at 31. This is the impugned order.
This is retail, na?
Yes, well, some fine has been imposed. Subject imposition of penalty.
Mr. M.K. Chaudhary, you don't appear for this Indian Oil Corporation.
After that notification of the senior advocate, I have to resign as the standing counsel of the ICML because of.
He will appear then. Mr. Sharma will appear. You are the standing counsel of IOCL, na? Okay.
This has reference to a complaint lodged by Arun Goswami, husband of Srimati Madhavi Goswami, regarding non-delivery of refill cylinder and consequent show cause notice letter, complaint dated 16/2/26. As per the complaint, the consumer had booked a refill on 5/2/26. However, the delivery was not effected until 11/2/26. It has further been alleged that refills are delivered only after consumer personally visits the distributorship showroom and requests the same. On 11/2/26, when the complainant visited your showroom at around 11 a.m., the premises were found closed during the working hours. Subsequently, the consumer approached the IOCL and refill was delivered only after intervention from his office on the same day. The above act constitute violation of the following clauses of the marketing discipline guideline. Clause 2.2.8, minor irregularity, deliberate delay in refill supplies against refill booking. 2.2.6, minor irregularity, showroom kept closed on working days during working hour. Now, my lord, on 2 count, I was found, my lord, guilty. There was a deliberate delay and showroom was kept closed on a working. Lord, my reply is at page 26, my lord. This was the reply which I gave, page 26. It is most respectfully submitted that allegation of deliberate delay is factually unsustainable. The delivery timeline was governed by systematic constraint and objective logistics rather than any willful negligence. Non-business hour booking The refill was booked on 5/2/26 at 9:59 p.m., well after the official operating hours of the distributorship. Operational turnaround time, excluding the intervening Sunday, that is 8/2/26, refill was delivered on 11 to 2:45:58 p.m., totaling 5 effective working days. FIFO, that is first in, first out backlog drive. During this period, the agency was aggressively focused on reducing general backlogs. We strictly adhered to the first in, first out methodology to ensure equitable distribution. A 5-day window during a backlog reduction phase constitutes a reasonable operational period. Now, this is most important, Milord. Technical impediment. A critical systematic barrier existed. The delivery authentication code was not generated by SDMS until 11/2/26 due to persistent network issues. Under current SDMS protocol, the DSC interlock strictly prohibits LPG release without a valid code. Consequently, delivery was legally and technically impossible prior to the code generation on the day of delivery. My Lord, the issue is, yes, it was booked on 5th night, and it could not be delivered because, my Lord, the DSC was not generated by the oil pump. Because DSC would be generated now, my Lord, that will be in the consumer's mobile phone, and based on that only we can deliver. It was generated on that. My Lord, in the imprint order, they do not speak about this aspect. And secondly, my Lord, there was a bereavement of a my Lord, in that locality. That's why for 2 hours, all shutters were down in that particular locality. So, my Lord, I have been imposed a fine of 87,000 rupees. Well, unless DSC is generated, where is the scope of I giving you? Lord? That is consistent with the policy of the oil company. Lord. And no complaint have you have made the complaint.
The order which has been passed on page 31.
Yes, my Lord. I have read it already. Lord. And the impugned order, Lordship will find it page 33. Hence, penalty on account of distributor commission is 87,000. Yes. In the context of delivery register for the period 6/2/26 to 10 has been verified, the following observations have been made. On 6/2/26, out of total 324 refill delivered, 22 refills were booked on the same day and delivered on the same day. My Lord, but where have they said that when they generated that DSC? That is the most important, my Lord. Unless DSC is generated, I can't do. And my Lord, I don't cater to the only one area. I cater to 4 different areas. My Lord. And FIFO and all that, these are normally, I mean, this is followed by all the distributors, my Lord.
But this technical thing which you have was putting out.
Yes.
How the, an impediment when from 6 to 10 to you could very well.
No, my Lord.
In various.
In case of these deliveries, the DSC was generated. My Lord, if DSC is not generated, my learned friend also knows, my Lord, it cannot be supplied. Because only when, my Lord, the DSC number to tally with the number which is given to them, then only the payment will be accepted. My Lord, all that I am submitting, my Lord, I have already been penalized, my Lord. This 87,000 is not a matter of rupees, my Lord. It's a question, it's a stigma, my Lord. Therefore, Lordship will examine this matter, my Lord. Let them not record, because tomorrow they will, my Lord, otherwise deduct it from my account. Yes, tomorrow. Lord, in my petition also, I have clearly taken this point, my Lord.
Why haven't you filed an appeal?
My Lord,
Why haven't you filed an appeal?
there is no appeal provision.
Page 53.
50
Page 53.
major irregularities, my Lord, against major irregularities. Appeal is maintainable against major irregularities. And my Lord, where is the deliberate part, my Lord? First of all, there could be negligence, but it has to be deliberate. And the shutter was down for 2 hours because then adjacent my lord, showroom, the owner died. He was a bereavement. That was for 2 hours. And if your lordship would kindly come to page 52 for a moment, my lord.
For minor
3.6.
irregularities, they have not even given an appellate forum. And therefore 226. And for major irregularities, they have given an appellate forum for which year? Then Mr. Sharma, consider submit a representation to you and you consider that. I think better off because these are factual things. How can you look into this? These are technical things. Let an authority above the authority which is there.
Yes.
Which is who have imposed it. Look into it.
That.
You look into it. Why should I look into it?
No, in fact, my lord, there are two instances which have been pointed out, 2.2.6 and 2.2.8. 2.2.6 is pertains to the issuance of the DAC number. I sought instructions, my lord. 2.2.6, my lord, the lordship would categorize deliberate delay, my lord. 2.2.6 and 2.2.8. Now, 2.2.8, my lord, is based upon the generation of a DAC number.
No, 2.2.8 is deliberate delay.
Deliberate delay. Now, deliberate delay.
2.2.6 is showroom.
Yes,
closed on working day.
My lord, true. The two clauses based on which the impugned order was issued. Now, for 2.2.8, the deliberate delay was caused due to the delay in generation of the DAC, the delivery authentication code number. I saw the information from the corporation. Now, this is an automated number which ought to have been generated, but that was not the case in the petitioner's case. But 2.2.6 admittedly had taken place. And under 2.2.6, my lord, we have taken the action of what we sought to take by imposing a penalty. Now, your lordship will.
So you are not taking an action under 2.2.8.
No, we did that. We did that, my lord. Now, as I understand, because I saw instructions also, my lord, the DAC number, what happens is that if I am a customer, I give a missed call from my registered number to a particular toll-free number. That is when the DAC number is generated. Now, that inadvertently, my lord, did not happen in this case. So, right or wrong, my lord, 2.2.6 is 2.2.8 is also taken out of the purview. 2.2.6 remains an admitted case of having the showroom shut down during working hours. Now, it's a public function, my lord, that the retailers have carried out. And the impugned order was based upon that. Now, if the lordship will see, it's a third instance, not the first instance. The third instance of both 2.2.6 and 2.2.8, which is taken. Now, the other prior instances, my lord, we don't have information, neither the petition carries records of it. And the action that we have taken, my lord, under the guidelines itself, my lord, at page 47, minor irregularity. The third instance. Now, all of these irregularities, my lord, read together or read separately would attract the provision that we have taken the action based upon that. The lordship will dispose
So
of.
you therefore say
My lord.
2.2.6 or 2.2.8. Yes, admittedly, let us take the case of the petitioner that there was no DAC notice or
Assuming as of
generated. It would be a violation of 2.2.8. But then also there is a violation of 2.2.6. And if it is a violation of 2.2.6, which is the third instance, then you, as per 3.2, you can very well impose this penalty.
Yes, and this penalty was imposed based on this formula. So we have not gone out of our own book, but the lordship directs us to take a stand on the presentation if they so prefer. We do that.
No, what, Mr. Chaudhary, what do you say about the allegation
Yes.
of 2.2.6?
Please come to page 27 for a moment. My reply. Clarification on clause 2.2.6. Regarding the observation that showroom was closed at 11 a.m. on 11/2/26, we submit the following. Temporary suspension of operation during the first half of the day was necessitated by local bereavement
the passing of a highly respected elderly resident in the immediate business neighborhood. This was a localized sensitive community exigency and does not constitute a routine or a deliberate closure under MDZ direct definitions. But this, my learned friend himself admits that while the physical shutters were temporarily lowered, the contact numbers of the manager and proprietor remain prominently displayed on the agency showroom. These lines remain operational for emergency grievances. The complainant made no attempt to utilize this displayed contact point to communicate his urgency. That's why we have made the complainant also a part. And one of my learned friend himself admits that 2.2.8 is not attracted because assuming, yes, because you say it was not generated in this case.
Preliminary inspection. Preliminary inspection that I have my functioning of the DAC, it's an automated system. So I'm not assailing on that ground ever. 2.2.
Now tell me one thing. If they want to close it, can they close it on account of this bereavement? What are the steps they are required to take?
Prior intimation to the IOCL. Prior intimation to the IOCL.
Where is it mentioned in
It
your
has not
guidelines?
been mentioned in the guidelines.
So, but that is your reason at page 32.
True,
Kindly see
true, that we have
2.2.
taken account. We have taken that down.
Yes, you have said that
Yes.
they should have informed the field officer and ITO official beforehand so that the office remains informed to reply to the consumer queries. So therefore, you have brought in an aspect which is not mentioned in the guidelines as regards 2.2.6.
2.6 is, if it is to be read in its entire totality, that no other reasons for substantiate closure during working.
Now, is it mentioned about when can there be a closure?
Six. No, it only says showroom kept closing on a working day during closing. They do not explain further.
Then
At page 42.
Then chapter 3 talks about the punishments, my lord. So
Now, kindly see here,
my lord,
kindly see 1.6, page 38. Roman 5.
my lord.
Where is it mentioned that it has to be kept? Yes, there is a penalty for closing on the time. Now, as per the working hours, you have to mention it. But now, if you do it, then there is a penalty as per 2.2.6.
Kindly similar page 39. The distributor shall provide one telephone connection, landline or refill sales also, which we have done, Milord, for having monthly refill sales, etc. Well, I think the action was too harsh, Milord.
Page 38, my lord, as I understand from the entire reading of clause 5, my lord, Roman 5, only holiday notices should be displayed well in time. As I understand, there should be a notices to the holiday period. Now I understand, my lord,
These are guidelines.
it's a guideline.
But what about the agreement? You must be having a distributorship agreement. There might be terms and conditions.
There might be terms and conditions, my lord. The copy was just served on us recently, my lord, so I could not get the
No, Milord,
instructions as to.
unless a consequence is provided.
The consequence is provided. Consequences by minor area is 3.2. It is provided. Now the question is that you are to keep it open and you cannot close it. Because you have taken into it that you can close it, but duly informing.
In prior indication.
But where is that?
But that I'll need some time to.
Then we have to see.
Your lordship, for a short while, my lord, your lordship, it's a shorter date, my lord. If I can satisfy this court in the next day, then the lordship.
Issue notice making it returnable on 29th May, 29 May 2026. Mr. M. Sharma, the standing counsel of the IOCL, accepts notice on behalf of the respondent numbers 1, 2, and 3. This court is, however, not inclined to issue notice upon the respondent number 4. Extra copy of the petition be served upon the respondent numbers 1, 2, and 3. Upon Mr. M. Sharma, during the course of the day. The petitioner herein is a distributor of LPG of the respondent corporation. The grievance of the petitioner is the order dated 30/3/2026, whereby in terms with clause 3.2 of the Marketing Discipline Guidelines 2022, the LPG distributorship, the petitioner have been penalized of an amount of rupees 87,139. The grounds on which such the impugned order is passed is on account of violation of clause 2.2.8 and 2.2.6 of the distributorship guidelines 2022. In terms with clause 2.2.8, minor penalty can be imposed if there is a deliberate delay in refill supplies. And similarly, in terms with clause 2.2.6 of the said guidelines, minor penalty can be imposed if there is a closure of the showroom. On working days or during working hours. Mr. K. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, submitted that there was no deliberate delay in the refill supplies insofar as the request made by the respondent number 4. Inasmuch as without the delivery authentication code generated at the end of the respondent corporation, the question of releasing the LPG cylinder does not arise. The learned senior counsel submitted that this particular plea was duly taken in the reply to the show cause notice in the email submitted by the petitioner on 1st of March 2026. However, a perusal of the impugned order dated 30/3/2026 should show that this aspect was not dealt with. Insofar as the violation to clause 2.2.6, the learned senior counsel submitted that on account of that, the first half on 11/2/2026, the shutters of the showroom of the petitioner were closed, were down on account of temporary suspension of the operation during the first half of the day, which was necessitated by a local bereavement on account of the passing of a highly respected elderly resident in the immediate business neighborhood. The learned counsel, the senior counsel submitted that the said aspect were duly taken note of by the respondent authorities in the order dated 30/3/2026. But on the ground that the petitioner did not inform the field officer and IDO officials beforehand, the penalty has been imposed. The learned senior counsel submitted that a perusal of the guidelines of 2022 would show that there is no necessity of any information to the field officer and IDO officials beforehand. And as such, the imposition of the penalty in terms with clause 2.2.6 is required to be interfered with. Mr. M. Sharma, appearing on behalf of the respondent, submits that he would obtain necessary instructions and bring on record the stand by filing the affidavit on or before 22nd of May 2026. Petitioner granted liberty to file reply thereagainst. This court further duly takes note of the submission made by the learned senior counsel that there is a requirement for passing interim directions inasmuch as the imposition of the penalty of rupees 87,139 is not the issue, but it casts a stigma on the petitioner, which results in an irretrievable injury to the petitioner. Taking into account the submissions so made herein above, it is the opinion of this court that the petitioner have been able to make out a case for certain interim directions. Accordingly, this court observes and directs that the next day, the imposition of the order dated, the imposition of the fine of penalty of rupees 87,139 by the impugned order dated 30/3/2026 shall be kept in abeyance. Yes. Mr. A.R. Bhuya.
Two 43 now.
Of Article 242.
Two 43C, madam. Two 43C, composition of panchayat. Subject to the provisions of this part, the legislature of a state may by law make provisions with respect to the composition of panchayats.
Where you have
243C, madam.
C. Okay.
Subject to the provisions of this part, the legislature of a state may by law make provisions with respect to the composition of panchayat, provided that the ratio between the population of the territorial area of a panchayat at any level and the number of seats in such panchayat to be filled by election shall so far as practicable be same throughout the state. General power might have been now might have been the Forest Conservation Act. 2023, now it is the One Sanrakshan Evam Sambardhan Obhiniyam 1980.
Now kindly come to the definition clause at Article 243. Gram Sabha. Gram Sabha means a body consisting of persons registered in the electoral roll relating to a village comprised within the area of the panchayat at the village level.
All electorates.
Electoral rolls relating to a village comprised within that. Now, village have been defined means a village specified by the governor by public notification to be a village for the purpose of this part and includes a group of villages. So there has to be a notification by the governor in that regard.
They have annexed a notification, my lord, saying that there are some forest village. Except item number 2, my lord, there are no forest villages. Item number 2, there are some forest villages. We have admitted on affidavit.
Means which one?
That the matter that my lord is taking up.
Now, which forest villages in which?
Number and Doyan, my lord.
Nambor and Doyang. And Doyang.
Rest of the cases, there are no forest villages, my lord.
So they have forest villages.
Yes, but we have also taken on affidavit, my lord, stand that these forest petitioners, my lord, are not figured in the Jamabandi. In
The
this
register.
Yes, my lord. If my lord takes up this case, this is Abdul Khalik, my lord, the same person who went on Supreme Court. Item number 2, my lord, has taken up. The affidavit file, the first affidavit having filed, my lord. Affidavit filed by the respondent number 5, my lord. Page 550, 515, the affidavit starts with. 515 affidavit starts with paragraph 6.
So in page 279, the concept of forest village is unique concept in Assam. A person entitled to stay in the forest village finds his name mentioned in the statutory register or Jamabandi register maintained by the forest department for the forest village, and the person holds a document for the land under possession. Mr. Bhuya, do you hold any document for that
Not, no, but
from the forest department?
we are the electorate within the.
No, electorate won't do. Because here, this is the only exception. Normally, a reserve forest cannot be used. But by filing an affidavit, they have created an exception.
Correct.
In respect to forest villages.
Right.
Now, forest villages, their stand is specific, that there is a Jamabandi register prepared by the forest department. Obviously, the revenue department inside the reserve forest cannot make it. So therefore, these persons have to be in the Jamabandi register issued, maintained by the forest department. And you would be holding a document to that effect. Now, you don't hold any document from the forest department.
Regarding the possession of the land, we do not have. Or
From the forest department.
no.
Because if you see section 4 of the Assam Land and Revenue Regulation, it says it is outside. The revenue have no business inside the forest area. So therefore, you have to hold some document, which you don't have. Now the question therefore in respect to those persons who, as the petitioners hearing, do not have that particular document, which is an admitted fact, the question has to be therefore looked into as to whether within the longitude and latitude by which they have found out,
They have earmarked.
whether the petitioners are within it. If you are within it, you are out. If you are not within it, it is not out. Now they say in their speaking orders that you are within these longitude and latitude. And therefore, the case is to that effect. Now earlier, when they filed their initial affidavit in opposition, they did not specifically mention as to how they found out. I still remember your submission made on that day that there were certain drones moving from here to there.
Yes.
That is what you could find out.
Right.
Now, in fact, on the basis of these drones, they have made the statutory satellite images, and thereby it has been. In fact, recently when we went to the Supreme Court, say one of the way which I think the state government or state of Assam also needs to do it. The Karnataka has a very good form of what do you call land and the land location. They have a particular app.
Yes.
Now, in this app, you just go and take a picture of where you are.
That exercise is still going on.
No, you take a picture wherever you are. And it will exactly show in which that number, partner number you are there. And even in the app, you can just find out each and everything.
as regards all this small thing, everything is being given.
Even
The state government also can
owner's
do
name are
something.
also visible.
Hmm?
Owner's name of that.
Everything is visible. So in fact, that was what was shown on that day. But they were also showing that this particular, how nowadays you have the dark numbers with longitude and latitude. Now you have these patta numbers. Now recent pattas have longitude and latitude. The reason why they have the longitude because they are in a position to do so on the basis of these scientific things by superimposing it. So therefore, in respect to these cases, what is your plea now?
Lord, my plea initially, my lord, the maps which have been prepared by my respected senior client has said, my lord, that this is a map relied on by the Survey of India. Now, my lord, these are all electronically generated documents. Now, just my lord, today only I could come before my lordship, my lord, when this affidavit in item 2 has been filed. So, my lord, I have not cross-checked or verified that whether these household which they have shown in these maps fall within the area or not. That
I'm not concerned with
Fine.
that, whether it falls within the,
my,
I'm not on that.
my
But this is the boundary
boundary, my lord.
which they have found out from the map.
My lord.
Whether you fall within it or not, but they have specific longitude and latitude.
That is their
That
stand.
is,
My
they
lord,
have it
my
on the paper. So my therefore the order would be, which I am probing, is that in respect to this area, which is the longitude and latitude, it being a reserve forest, the question of any person being there does not arise. If you are outside these longitude and latitude which they are mentioning, whether you are inside the road, social marks are you or not, I'm not concerned. But if you are outside there, you are safe, but you are not.
But my
So
lord,
when they are vacating out there, they have mentioned you are falling under this longitude or latitude
That
out
is
there. So they will carry out that. So we are. You can't
Not-
you under this. Because Mr. Bhuya, one thing I make it very clear.
my lord.
Reserve forest, the sport is not going to touch.
But my
You
lord,
may be having a good case for being given a settlement by the government in some other land.
that is fine.
Something from there.
Fine.
But that is a different form of action which the government and the welfare state is doing in the revenue department.
Fine.
But the forest department under no circumstances can come within it. We are to protect the forest. It is in fact the fundamental duty as section article 51A. That is the fundamental for every citizen to maintain the forest fund. Therefore, the question interference with that aspect, if you fall within it, within the longitude and
It is their stand, my lord. It is their stand that we fall within the reserve forest.
yes,
They
but,
say.
but I am now going to pick my order as to which is the longitude and latitude within which that it will fall
Fine.
and make it a part of the order.
No.
And when they say, so
Fine.
if you are beyond that, you are safe.
But
You
my
are
lord,
not on that.
as per their map, the latitude and longitude which they have mentioned, my lord, and even they have earmarked through blue dots and the green
I'm
dots.
not the blue dots. The blue dots I'm not there. They may say about the blue dots whatever may.
Fine.
But my question is, within this particular longitude and latitude which they have, you see, the blue dots cannot be a marking of a particular petitioner here, he, there or not,
My
not
lord,
there.
my lord.
They can find out from there, whatever they are. Is that this particular in the area of the longitude and latitude of the reserve forest. And if it is the area within this, they have a right to evict any person
Well.
in view of the forest conservation, as well as the other laws that are. If it is outside there,
Then we are
so
safe.
therefore my order, your basic submission out here, neither you come under the 2006 Act. Because you don't have a right, you have not been in possession for a period of the 75 years. Or you do not belong to the feeding class, community. But therefore you do come under 2006. You don't have a document given by the forest department that you have your name is there in the document. You don't have a document.
But for the Tongias, my lord, we have that.
Let us not come to Tonga.
My lord.
This is the second thing which is.
Right.
The third is as regards the only question therefore arises is whether you are outside or inside. So they have a made this longitude and latitude, which this code under 226 cannot otherwise say. We cannot, because it is being done on the basis of a particular procedure being given. And that procedure, in fact, is the procedure which I say so. Without even reading, this is the procedure now which is being followed. How it is done there? You have the old map, you take photographs from the top by way of drones or whatever, you take photograph, then that photograph is superimposed on the map. And thereupon, now then you have a particular rover machine, this rover machine provides the various longitude and latitude to the extent of just 2 meters, 2 centimeters. 2 centimeters. The accuracy is in 2 centimeters. Unlike a chain, it can differ by around 500 feet. But if you do it by chain, which earlier used to be done from this chain to that chain, there might be a difference around 500 feet. But in this case, it is around 2 centimeters. This is the accuracy. So therefore, if it is done within this, if you are outside, well, if you are inside, within this quantity, you are safe.
No, my lord, if my lordship approves this map, this latitude and longitude, my lord, then there is no scope for us that we are outside. My lord,
I can't help it with that.
no,
Because
my
of the
lord,
fact that this is being the longitude or
My
latitude, it is given by them.
my lord.
And now the fact remains that can you give any other evidence to the effect?
No, my lord, other evidence, my lord, my respectful
You
submission.
had the time of this file. I have also got the file edition and reading. My question is, why should this court not trust the map, which is based upon that which they have given in a particular manner? How this is being done? So if
I am
this
not,
is
I am not, my lord, I am not saying
then
that.
and
my
if
lord.
you have a case, well, you should.
No, my lord, I am not saying, my lord, that these maps are not believable. I'm not, my stand is not there, my lord. Under the Indian Forest Act of 1927, my lord, if you go by the provision of section 2 and 4, my lord, when this notification is required to be issued for the purpose of declaring a particular land to be a reserve forest, my lord, then there should be a proper demarcation of an area and there should be a map.
Why should I go by the 27 Act?
No, because, my lord, this is.
No.
Milord,
We
Milord.
don't need to go to the 27 Act before. There is a reason why we need not go to the 27 Act, because these were the part of the Part B states. And Part B states were always covered under the regulations of 1891.
Now, Part B states are excluded from the operation of this act also.
So therefore, the 1927 Act would not come in. So they have the 1891 Act.
For the rest of India, not for Assam. Forest Act 27 is for the rest of India, not for Assam.
No, because
Why not even in the
why
18
did them? In fact, I think this aspect in my Mizoram judgment, how it became. That's the focus on my state of Mizoram. Now, what do you say about the Korea one?
Milord, in regarding this, Milord, the panchayat plea, Milord, which we have taken, if my lord may be pleased to take up the panchayat plea and the notification, Milord, which they have issued. I just want to draw my lordship's attention to the notification issued by the governor. Milord, yes, Milord, that notification, my lord may be pleased to find.
In this collect,
Yes, in Abdul Khalek also, Milord, we have an annex, Milord, my lord may be pleased to find, starts at page 185. 185, annex at 3. This is a notification of recent date issued by the governor, Milord. Got it, Milord, page 185, Milord. In exercise of the power conferred under subsection 2 of section 5 of the Assam Panchayat Act 1994 as amended, so and so, of the meeting held on, the governor of Assam is pleased to notify the following Gaon Panchayat along with their correspondent villages under the Gulaghar district. So, my lord, these are the area, and my lord may kindly see the name of villages wherein we are also being, our village's name has also been, my lord, reflected in page 186, my lord. Gulaghar South, my lord may be pleased to find Gelazan and all the areas, my lord, wherein we are residing therein, my lord. Our villages has also been included in this notification. So now if you go by the provision of the constitution, my lord,
we have this constitutional protection, my lord. The constitution says, my lord has just gone through the provision of article 243, my lord. I am again reiterating, my lord, article 243 definition. Gram Sabha means a body consisting of person registered in the electoral rolls relating to a village comprised within the area of a panchayat at the village level. So now, my lord, this is the village level in a particular area wherein, my lord, our name had also been included in the electoral rolls as a, my lord, resident of the said particular area. Now, my lord, panchayat again defined. Panchayat means an institution by whatever of the self-government under article 243B of the, my lord, of the rural areas. So panchayat area means the territorial area of a panchayat. And, my lord, this is an area, my lord, under the village, which is also falls within a territorial area of the panchayat. That is my, my lord, limited understanding and respectful
So
submission.
why the Panchayat Act came into, why chapter 9 was brought in within the constitution?
My lord, my lord.
So
Chapter,
that
my lord,
there is decentralization of power,
power, correct,
which is being there, thereby giving certain rights to the person.
my lord.
But does it, by this act, does it take away or interfere with the Forest Conservation Act?
No, my lord, this is the constitution, my lord, not
The
any
Constitution-
law.
Constitution says
My lord,
that tomorrow a village, even in the forest,
more correct. That is the
in the
protection. my lord.
forest also, the Constitution does not say anything about forest or anything. This chapter
My lord, no, no.
does not
Forest,
say
no.
anything about the forest.
my lord.
But however, it says that the relevant 43
Yes, yes, my lord.
village means a village specified by the governor by a
Yes, sir.
public notification to be a village for the purpose of this part and includes a group of villages that specify.
Specified.
So this is the notification which you are referring.
I am relying, my lord.
So this is a notification which has been issued
My lord.
in terms of
Subsection 2, section 5. my lord.
of the Assam Panchayat Act, but this is also in consonance with
The constitution.
243A.
My lord, my lord.
Now, I will see constitution, there shall be constituted in every state, panchayat and the village, intermediate and district unit in accordance to the provision. Notwithstanding anything in clause 1, panchayat and intermediate level may not be constituted in a state having a population of less than 20. Subject to provision of this part, the legislation of the state made by law make provision with regard to the composition of panchayat. I think that the ratio between four. So by virtue of section 5,
My lord.
the power the state have can claim panchayat, even a forest village
My lord.
as a part of a panchayat.
Part of the panchayat. Panchayat.
Now, being a part of a panchayat, you get can you take action or can you remain within the panchayat in derogation to the forest conservation?
My lord, my respectful, my lord, reply to the, my lord's query. My lord, when the very evolution of the my lord, the concept of panchayat is the source under the part 9 of the constitution, my lord. So part 9 has specifically dealt with that in what manner or whatsoever manner the panchayat is required to be constituted. Now, the source of section 5 subsection 2, my lord, arising out of this part 9, my lord. Now, my lord, my respectful submission regarding is that, my lord, no doubt that the Forest Conservation Act is a, my lord, 1980, the parliamentary legislation. So the issue of, my lord, the law of repugnancy may come into play also here, my lord, that it will override the everything state act or legislation. But, my lord, my submission is that, my lord, that can it override the part 9 of the constitution, of the 1980 act? Because the, my lord,
Part 9 does not say anything about revenue or village, forest
My lord.
village or anything.
as a whole, my lord,
It
as a
says about there shall be a panchayat.
panchayat, it may
In
be
all
within the, my
villages.
lord,
Villages which have been declared by the
governor,
governor.
governor. Now, here is a
But
clear
interestingly,
declaration, my lord.
interestingly, if you see, as specified means a village specified by the governor by public notification to
Right.
the village for the purpose of this part
Right.
and include the group of villages.
Correct. Now,
Now to see this notification of 15th of October 2024, it says about so and so in pursuance of you see, they are not saying to the villages within for the part, for part 9.
no, my lord. Once the issue of, my lord, section 5 subsection 2 will come, my lord, then automatically it will have an access with part 9, my lord. It is not expressly required to state in the notification. This is my limited understanding and respectful submission, my lord. Because the source of 5.2 is evolved from part 9, my lord.
But Mr. Bhuya, tell me,
What?
a panchayat, the people for which this amendment, the
Part 9 amendment,
part 9 amendment, the 73rd amendment
Yes.
came into being in 1992.
my lord.
It was decentralization of power,
Oh, exactly.
meaning thereby those persons who are already there,
My lord. They will have.
they have been now instead of the state government exercising all the power
My lord.
in respect to those villages,
My lord.
it would now go back or decentralize to those villages. This decentralization of the power, which the state otherwise would have exercised,
My lord.
would it confer a right upon it to remaining a reserve force?
Now, my lord, the regarding the decentralization, my lord, and the other issues is no doubt there, my lord, but the Panchayat Act itself being a benefited legislation, my lord, along with the, my lord,
No.
My-
This is not a question of beneficial.
my lord.
It is the case by which the state, you cannot, the moment you can't say it to be a beneficial legislation,
Right.
no, not a benefit. The power which is to be exercised by the state in respect to various things, like in respect to a mall, in respect to a market and all these things, if the
Right.
state otherwise is there, it will now go to the various small units, like the ground panchayat, the Anchalik panchayat, and the Villa panchayat, they will be exercising.
My lord.
And the reason why, because the state is giving up these powers to be exercised by the panchayat.
Correctly.
But that is one aspect. But does it entitle you on the basis thereof to remain in the forest land?
Because my respectful submission in this regard is that, my lord, it will, my lord, give us that, my lord, power to remain there on the strength, my lord. Why I am submitting, my lord? Because, my lord, if we go by the definition and the population, which the later part of the constitution deals with, if my lord may be pleased to peruse the article 243A, my lord, that is a Gram Sabha. Now, my lord, our benefited legislation and everything, my lord, whatever benefit government has extended, my lord, it by virtue of this 243A. Because the Gram Sabha is required to take any policy decision of the who are the citizens residing therein, my lord, in the electoral role as a panchayat citizen. They are entitled under the recommendation of the Gram Sabha under 243A. And
Now tell me whether the
My
Gauhati panchayat
My lord,
And the power to evict someone.
Gaon Panchayat cannot evict you. There
The
is-
power, no.
No, they cannot.
Kali Panchayat, they don't
They
have.
do not have. it.
Villa Parishad, they don't have that.
No.
Power still is reserved with the state.
State. Either
this
revenue or by the
power-
forest. ministry.
Now, what is the power which has been granted to the Panchayat? This
My lord, the
power
Panchayat
and
power
authority
is
and
not.
responsibility. Can you see?
My lord.
43B. Subject to the provisions of this constitution, the legislature of the state may by law endow the layer with such powers and authorities and may by necessity enable them to function as institution of self-governance.
My lord.
And such law may contain provisions for the devolution of powers and responsibilities upon the panchayat at the appropriate level, subject to such conditions as may be set. The preparation of plans for economic development, social justice, the implementation of schemes for employment, power to impose tax, the state employed by law authorized the panchayat to collect tax in appropriate form, assign panchayat the duties of the earth, providing of such granting it, each way. So therefore, there is no power which has been granted. In fact, the abolition of the power which the state exercises. So therefore, if you see the Panchayat Act, particularly the provisions of this state, let me see functions of the Panchayat at section 19. These are the various functions which is otherwise the responsibility of the state. Now, these are now being decentralized and given to the Gauhati Panchayat.
Nothing about politics. It doesn't speak anything about politics.
So
The power.
therefore, now let me see, the power of tax is the sovereign power which the state exercises. Now, this particular power is being decentralized to the panchayat, is for 25. So therefore, the question is, power which is there with the state is being decentralized. But does it give you protection from the Forest Conservation Act? Is the question.
No, my lord, the Forest Conservation Act, my lord, no doubt, my lord, it is for the purpose of conservation of the forest. I'm not disputing and denying. Now, but those persons, my lord, who are already there, as the protection of the, my lord, it is the conscious, my lord, may kindly appreciate, my lord, we have been provided with the every amenities and every benefits within the said area as a panchayat citizen or as a electoral of the panchayat, all the benefits they have provided. Now, my lord, now they have
Except the
after,
patta.
no, land patta has not been given, my lord, and which we are still, my lord, we are still hoping that, my lord, if they not some policy or decision is being adopted, then we may get also, my lord. But my lord, now we are on the verge of eviction, my lord, no doubt. But only, my lord, my lord, I have to submit fairly before my lord, that we do not have. My lord, we do not have any land documents, but that is an admitted fact, my lord, and. we
So
do not-
therefore, Mr. Bhuya, my only specific query to you is, does becoming a member of the panchayat save you from the operation of the Forest Conservation Act or the Forest, Assam Forest Regulation 1891? That is the only issue.
Right.
And it appears to be this notification would not help you out unless, because you see, while they are bound to say that there are forest villages, they are bound to say. And also they say a person having a document from the forest department to reside there, they are bound to keep them and protect them. But similarly, you also have to show that you have something else, because they are otherwise bound. Although normally the Forest Conservation Act, they cannot have anybody use the reserve forest for any non-forest purpose. But if in this case they use it, they have on their own put it out there before the Supreme Court to the effect that, look here, we have forest villages. So therefore, now if there is a forest village and you are you have been given a particular document, you are bound to they are bound to keep you. But if you are not, you don't have that, There's no way out. And I don't think the Panchayat Act would save you from that.
Just one more.
My lord,
Article
one-
243, my lord, definition clause itself says village. Village means a village specified by the governor by public notification to be a village for the purpose of this act, not for any other purpose.
For the purpose of this part,
Part 9 is the panchayat. For the purpose of this part, it has to be confined to the panchayat only. Devolution of local self-government. Nothing else. You cannot go to include my lord forest. And secondly, in this case, my lord, in the initial affidavit, my lord, we have clearly indicated how, in item number 2, my lord, that there are certain forest villages and these petitioners have no document to their effect. my lord.
they have not produced, they don't have the document also, Mr. Bhuya had
Yes.
clearly conceded to them.
no, my lord, this villages, my lord, wherein we are
And as
now
my-
residing.
As my lord has already, my lord, indicated in the recent affidavit, my lord, the long, annexure B, my lord, the longitude and latitude after this exercise, my lord, annexure B, we have my lord, placed on record the longitude and latitude of both these forests. Page 566, my lord, today's affidavit. Page 566. These are the longitudes and latitudes to which we will confine our eviction. Page 566, Doyang are boundary coordinates and numbers out are 566 and 566.
That's 566 pages of.
But today's item number 2 affidavit. This one. After the methodology, my lord,
Yeah, annexure B.
yeah, annexure B,
This is for Doyong
Doyang, next page 566A is for numbers of
and the
All-
other one,
number, my lord.
Workman.
In all cases, my lord, we have
Very
given.
good, longitude and latitude.
This case parties to my lord, not Lutuma, my lord. Lutuma in the other affidavit we have indicated.
They come back to where it is, right? Okay, let me come back in 5 minutes. We hear on the Tongia. Otherwise that is.
Public.
Let's look into the Tongia case.
My lord, regarding this, more submission, my lord, is that, my lord, the area was originally, my lord, notified long back, more than 100 years. my lord. Now there is a chances of, my lord, that the changes in the topography and the geographical condition also, my lord. There is a river flowing in the said area, my lord. So therefore, there may be a changes in the area and shifting of the, my lord, geographical area also there. So, my lord, the map which they have produced, my lord, we have found out some judgments, my lord. These are all electronically generated documents. So these documents, my lord, are required to be certified by OFS 65B earlier, my lord, Evidence Act certificate, my lord, or the make a heavy reliance. Now those judgments are also, my lord, categorically safe. Now, my lord, these maps, now where from and who has prepared this map, my lord, is also not very clear. So whether therefore, my lord, if my lord give me a one chance, my lord, to cross check or verify, because this maps has been produced right now, my lord, in the premises of the court, my lord, we have received some of the maps, my lord.
You got the copy?
Yes, my lord, just in the court premises, my lord, in the court. my lord. That's why, my lord, if,
No, Mr. Bhuya, I'm
My-
satisfied with the argument of the
my lord,
If by being for other, we are really looking out there to whether the exercise of jurisdiction which they have done was in conformance with the judgment of the Supreme.
no, my lord, that,
Now, that is the only thing. Tomorrow, if by the truth out there, they not to evict you, all these things, they will produce these maps with the.
my-
That is not-
no, my lord, we are in a, my lord, that is an another issue, my lord, but even then, my lord, the map which they have relied on, my lord, is a map just being produced recently or they prepared. Now, my lord, whether these maps, my lord, says that these are the blue dots within the reserve.
No, I'm again saying the blue dots, whether you are, blue dots are you or not, are concerned with the. I'm concerned with the two boundaries, the boundaries which have been mentioned in the particular longitude and latitude. All thing is done, you are.
No, they are saying that, my lord, we fall within, my lord. So
They are saying that you fall within it. You can check it out from yourself. When you are there, out there, wait out there, try the, stand on your band and find out with your iPhone or any Android device and find out whether you are there in the longitude and latitude, it will clearly apply, appear out there. in the compass. Whether it is your longitude or latitude, there's no problem with that to find out. Just for example,
They stand in the area they are in policy.
just for example,
No, it is not a, case that we should not stand in our area. We have to stand in our
The
area.
way the petitioners are disputing, my lord, from the very beginning, there is no end to that dispute. my lord.
now just for example, here, yes, here, the longitude here is 26 degree 11 42 north, 91 degree 47.6 east. This is my longitude latitude here.
But my lord,
They will find it out of them. They'll find it out whether you are inside or not. That is over.
my lord, that,
So there's no problem with that. For that, whether you follow it or not,
we can,
after taking the judgment, you just take it out there and find out, stand on your land and find out as to whether where you are. It is available to everyone. Everybody has a mobile.
my lord, another, the judgment of
Provide
the,
one or mobile for both sides. You know,
my lord, the, in the appeal collect judgment, my lord, the honorable apex court has held that they are required to, my lord, examine the every merit of the case.
merit, you see the merit is, what is your merit? The merit is whether you come under the, what is the fact? No. The merit is whether the forest department has issued any pata to you, which is no. The merit is as to whether you have any other document to show that by which the forest department is permitted. That is, any other document which the forest department is permitted to read it. And thereby you can allow and thereby granted you a right to remain there. Heritable right has to be given. Now, just for example, forget about this. The state to wastelands of the state of can be evicted, taking into account that the law which permits them to, but you have to be specifically authorized by the state to use the land. Now, reserve forest is the land which belongs to the state, and it is reserved and now being protected by the Forest Conservation Act. The problem is, as regards the wasteland, in the difference between the wasteland and the reserve land is the reserve land is further protected by the Forest Conservation Act, which is not there in respect to the state wasteland. So therefore, you are to be, these are the merits on which are to be looked into. And this is the argument which you have made before. Now they have considered and find out that you have within this particular area. This is their decision. That you fall within the area and you document which you show that you have a right to bring for them. It's a merit. But now you have before us to say that this is not the land where it is. This is your only contention. Now they have come up with this particular map and say that this is here, this is it. This is how we found out that this is the area in how it is. Now therefore there is nothing to decide on this.
No,
There is just been decided.
my lord, it
Yes,
is,
I think anything else the division bench will clarify or even the Supreme Court will clarify, not me.
my lord, not the,
Now,
is
Mr.
like-
Banya, let us come to the second issue.
my lord, the issue they have raised is like that, my lord.
Their issue is they have only substantiated their affidavit which has been filed earlier.
They are the informant, they are the prosecution, and they are the judge by themselves. my lord. They have said that you are, that is their stand, my lord. That is the issue, my lord, before my lord now. my lord.
Mr. Banya, you are before a court which is judged by himself.
My lord,
But therefore, the question is, I don't find that aspect to be here. You didn't get a stay order in many of the petition. I gave
my
you a
lordship,
stay.
my lordship,
So therefore, the concern is satisfied, these are the documents satisfied. me.
by the,
And therefore, I'm saying, if you are outside these four parameters, which have been mentioned out there
my
in
lord,
the lab,
my lord, my lord, may I pray for a, my lord,
don't say, argue on the problem.
my lord, only thing that latitude and longitude, my lord, and while if they are going to evict me, that we may be allowed to cross check or verify the latitude.
Hey, no, there's no problem with your,
That observation,
for
my lord, will
checking.
kindly be kindly.
You, the fact remains that you have to keep certain documents to this court to get effect, which by which you can say that these are not there. This is not your submission at any point of time. This is not your case also. They are out here saying out here that look here, this is the reserve forest. Reserve forest is based upon the 1916 or 1935. What is here? 1916. 1916 notification or 1927 notification is given under the soil. And this is the map, and this map from map you have got. So we will get a come to the second. Okay. Is them on people watching the look at page 209, I think 6 minutes. The annexure they have filed today. This annexure. How they have measured this longitude and latitude, my lord. That is important. Yes, I think so. It's additional affidavit. Our contention is that we are outside in the reserve forest. So item 6, annexure A. Yeah, this additional affidavit. My lord, the third paragraph. By notification number dated so 7 August 1928, issued under section 70 of the Assam Forest Regulation 1891. 5 of the Assam. My lord,
That's section 5.
yes. Following completion of the forest settlement officers and the governor in council declared that the land described in schedule thereto will be reserved forest with effect from 1st September 1928. The area so constituted was 9,216 acres. The schedule described in the northern boundary as demarcated in line 27 cents long at 66 degrees from a point on the right bank of the Borapani River at bearing number 213 degree from the trigonometrical station on Longjap. So basically it was 66 degree from the bank of the river, not the geographical latitude and longitude. In this 100 years, my lord, there is much scope for erosion, my lord. So the degree might be changed, my lord, and this benefit definitely goes to the petitioner, my lord.
No. How will the petitioner go?
Because hypothetically, my lord, if this court's coordinate is put in here for measuring this boundary, my lord.
No. Apart from that, they have a map. You have a map.
This original.
This
That is why this map was
actually,
required,
my
my
lord,
lord.
this original notification, there has a chance of sense, my lord. Because that was decided, that was measured from the bank of the river, and that was in the north, it was from another bank of the river.
Yes, that is because of that, my lord.
Therefore, my lord, and
We have done.
and earlier they have reserved also 2 times, my lord. In the next page, my lord, page 210. Thereafter, 2 partial de-reservations were effected by notification number so 13th October 1965, issued under section 28 of the Assam Forest Regulation 1891, as amended by the Assam Forest Amendment Regulation 3 of 1912, an area of 1,200 acres was declared to cease to be reserve forest for the purpose of rehabilitation of displaced persons from Mikir Hills and to provide land to local landless people, indigenous people. They are also indigenous people, local people, my lord, and landless also. The de-reserve area was bounded on the north by a demarcated line running from pillar number 1, a pillar covered with Rohimola tree situated on the right bank of the Borapani River. It was based on a Rohimola tree situated in the right bank of the river. So now, before 100 years, now the Rohimola tree is there or not, we don't know, my lord. And at a bearing of 183.5 degree for a distance of 46.40 cents from the original reserve boundary pillar number 2, eastward to pillar 12, situated on the southwest corner of the Amguri Bill. After crossing the Morazan branch on the east by a line running from pillar number 2 in a south. So that pillar, my lord, so whether that pillar, which was placed in 1922 and almost it's 100 years thereafter, how they can ascertain that pillar?
Rejected. Next. This type of submission would not find favor. Come to the Tungia one. Who has the
My lord, maybe please to take up item 7 WPC 1690 only. Lord, the petitioners are not the enforcers. First of all, my submission is that the notice which they have issued, treating us as an enforcers. Therefore, my lord, this notice is not applicable for us. We are, my lord, the Tongia settlers used by the forest department, my lord, for the purpose of forestation and other, my lord, ancillary works, my lord, related with the, my lord, development of the forest in a particular reserve forest area. Now, my lord, here is a case. We have to admit, my lord, that we are residing or being settling, my lord, as a forest employee within the forest area. Because, my lord, we have been employed recently by the forest department for the purpose of eviction of these people, my lord, who are in the other petitions, my lord. Settling up of the camp or making arrangement.
Where should you be appearing in that matter?
No, my lord,
You are being allowed to, you are the person
No, no,
who is
my lord,
evicting
because-
yourself.
yes, sir. No, my lord, why I am making submission, my lord, because the notice which they have issued is exactly same.
Understood, but
My
the
lord.
fact is, don't you think that it would not be proper on your part that you are the person who is evicting them?
No, my lord, we are not evicting, but they have said that we should be given assistance to them, my lord, the police personnel or the making up some camp or something like that, my lord, as a laborer. Not the force which we are being used, my lord. That is not the issue. So therefore, my lord, my first limb of submission is that, my lord, they have misconceived us as a, my lord, enforcer. We are not the enforcer. There is a provision under the rules, my lord, that the Tongia, who are the Tongias, my lord, that rule is already, I think, my lord, it is.
This is the rules of 1930. I have it.
My lord, that under that rule, my lord, there is a provision, if my lord,
Designed for the purpose of providing a
Mile.
source of suitable local labor
my,
and for forming and maintaining plantation and fungia
my,
and no caste which are not habituated to living and working in the forest are eligible for admission may admit new entrants to existing forest in accordance with the executive orders of the conservator. The boundaries of all the permanent forest villages will be demarcated by the boundary pillars and shown in a map together with all interior details as shown in homestead and so and a register shall be maintained of the houses in each forest village.
my lord. The subletting of land.
The subletting of land
Mile.
by a forest villager is not permissible in any circumstances, but with the permission of the divisional forest officer, servants may be engaged to assist in agricultural operations and their names shall be recorded in the temporary forest villager.
I will read rule 6, my lord. On the decease of a householder, the name of his male heir will be registered as a forest villager if he is considered by the divisional forest officer suitable in all respects. Or in cases where a daughter is the heiress, the name of her husband should be recorded as the householder if he is suitable for employment as a forest villager. The names of the heirs who are minor will be recorded as forest villagers when they become fit for work, or in any case, or in the case of females when they marry husbands suitable for employment as forest villagers. But nothing in this rule shall be held to be recognized as any heritable right in land allotted to a forest. But this was a 1930 law, my lord. Then Forest Conservation Act came, my lord. Then, my lord, see, there is a judgment of the Honorable Court. Even my lords have also delivered passed an order judgment, my lord, regarding, in that case, my lord, some persons were claiming for rights inside a forest village, my lord. So they were supposed to get the allotment, which was negated by a version, not permissible. This rule, my lord, was, my lord, discussed in the judgment of the Honorable Court. It's a pre-constitutional law, my lord. Goods. It's the division bench. Single bench, my lord. Elaborately discuss the provision. In the instant intra-court related is directed against the judgment and final order is checking the restrictions filed with the query. Hearing before being applicated from the prayer to direct the respondent to the forest department of government of the circle officer Pathakandi revenue service to take necessary steps for entering the names of the applicant in the Jamabandi register maintained for Port Salam. This rule was taken recourse to minor by the listeners. The learned single has rejected the request of the applicant hearing by giving due consideration to the provisions of the Assam Forest Regulations as well as the provisions of the Forest Conservation and and found that the rights that we agree to persons who are beneficiaries of the letter that is signed and the order that is signed so cannot exceed the right that have been provided in the regulations of 1891 and any indication of in these rules in these documents which will beyond the scope of the rules would not carry any legal sanction. The learned single has further considered that as per section 2 of the Forest Conservation Act, which begins with a non-ostensive clause stipulating that no state government or any other authority is empowered to make, except with prior approval of the central government, any order directing, amongst others, that any forest land or any portion thereof may be used for any non-forest purpose, and that any forest land or any portion thereof be assigned by a police or otherwise to any so and so. Then, paragraph 5 in the paragraph 9, madam. There cannot be any dispute that by virtue of the operating effect of section 2 of Forest Conservation Act, the court cannot direct the mutation of reserved forest land we made in favor of the appellants as there is complete prohibition on change of land use of this category of land, leaving the appellants at the liberty to take recourse to the remedy of the land. The remedy was to apply under the Assam land policy. Yes.
Yeah, the paragraph 37 goes against what you have stated in your affidavit before the Supreme Court.
But if we might not see the section 29 of forest regulation, there has to be a specific notification of forest. But because of this section 29, the stand was taken. Assam forest regulation. Constitution of forest, village forest, the state government may by notification the official gazette constitute any land at the disposal of the government and forest village for the benefit of any village community or group of village community and may in like manner vary or cancel such notification. Every cancels, state government may issue a gazette notification and cancel also. Power of cancellation is also there. Every such notification shall specify the limits of such forest. There is a case where these petitioners where some of them, my lord, were at some point of time allowed to do some forest activity. Or that's a Tangia is a purely temporary process, my lord. If we give no right to them, my lord, I have in my affidavit specifically taken that stand. And if we allow Tangias to remain inside the forest, again, my lord, section 2 of forest. After 1980, these my lord, arrangements were prior to 1980. After 1980, these things are not possible. And Forest Conservation Act specifically says section 2. Any state law, madam, notwithstanding anything contained in any state law, that will include Ponsire, that will include all orders passed by the state government. If my lord,
But I need to 31,
section
all
31.
the right claim any right other than the rights of a village community or village community. Forest is not village
Of this regulation. Reserve forest. How to notify it?
you have no right of it to fulfill the required. But right or the power to. Tell me how what the how the these rules of 1930 were.
In fact, my lord, rules of 1930. Judgment, my lord, honorable single judge has held, my lord, these rules of 1930 will be subordinate to forest conservation.
Yes, they cannot be because something.
In fact, my lord, some provisions, my lord, in my respect and some submission, my lord, some provisions of Assam Forest Regulation 1930.
Contrary to 21.
Exactly. Contrary to 21, contrary to forest regulation. Sorry. Yeah.
Additional powers of the state government. Generally, to carry out the provisions of this regulation, person bound to the officer and police officer. So that is 74.
Yes, sir.
Which is the clear state of fear that he has. They have been employed for the purpose of doing.
But even if we may not take recourse to Forest Rights Act, there is also Tongia is mentioned, ma'am. In Forest Rights Act also Tongia is mentioned, ma'am. But for that, my lord, they have to be either traditional forest dwellers or civil rights, ma'am. Merely because there was a Tongia system, ma'am, after 1980 and 2006 Act. Persons who doesn't fall under the definition of.
See the earlier judgment were being passed by the. They wanted to record their. Paragraph 37 of the judgment passed by the legislature saying brings in the concept of the Assam land in review, wherein says that section 2 is not applicable.
Section 4, revision 4.
But that judgment does not take care of what is mentioned in chapter 3,
Yes.
of the regulations.
Yeah.
The effect of the regulations stipulate concept of settlement of rights, like they have also differentiated the claim of any rights other than the rights of village community or group of village community for the benefit of which such state policies constituted shall be enshrined, recorded and provided in the same manner and described in chapter. Chapter 2 provides such manner is by publication of certain alia. Again, one has to look like for the game. Chapter 2 says about the
There is judgment of your lordship, madam. 43 and Dasarat Yana.
but they are not asking for recording of their name. What they are asking
Allow them to
is
stay there.
disturb with the promotion.
Then our name has already been recorded in the register, Milord, as a Tongia, like a Jamabandi. Not that record has been maintained by the department. We have asked for them to RTI. That has not been provided to us also. If my lord calls for the record, Milord, our name is very much available. Milord, we have made a part of those RTI applications. Milord, present affidavit. Look, the case which my respected senior friend has relied on, Milord, is a case for asking registration of their name or one kind of settlement of land in a, by virtue of a Tongia. Milord, here we are not, Milord, praying for any settlement like that issue, Milord, that as we are an employee, you have employed us from last 70 years. Now you are going to
Last,
Milord, from, we have the document of, Milord, the Tongia from 1970 certificate as we are residing therein. We have those documents also, Milord, that we are residing there.
where? Show
Milord,
us in this
yes,
case.
Milord, one.
Show us in the case of item number 6.
No, item number 7, Milord, page 169, Milord. 169, Milord, but kindly have a look, Milord. Milord, at page 160, 67, it starts, Milord.
Who are these people?
Look to my said fingers.
How are you connected with these persons?
Milord,
R.
please.
Roy and Soitia and others. Where are these people?
Milord, the petitioners are here, Milord, and some of the petitioners, we have annexed, Milord, those documents. And Milord, interestingly, Milord, they have recently made a survey of, Milord, this Tongia who are, they are residing there in, Milord, and then that.
Mr. Brian, let me tell you one thing. This is what these government officials have done or the state government have done This is contrary to the regulations. In 19, you see, the only way by which you can be granted the settlement or anything else is not by anything else except by the regulations of 1981, 1891.
But
1891 regulations are very clear how you can acquire acquisition the rights.
my lord, what
By way of these rules or anything, you cannot get it.
But my lord, in the affidavit filed in the Supreme Court, my lord, Honorable Apex Court, my lord, just I want to draw my lordship's attention to the order, my lord, which relevant paragraph of the Honorable Apex Court, my lord, kindly turn to page 206, my lord. Page number 206. Wherein, my lord, the paragraph 3 to 9 have been reiterated. I am not troubling my lord. Again, my lord, establishment, forest village is there. But they have said, my lord, may kindly turn to page 208. Paragraph 8, I am reading, my lord. The individual whose name is mentioned in this register or hold rights under the Forest Rights Act 2006 are not unauthorized occupants. Now, my lord, our name is already been registered in that particular, my lord.
No, whose name is mentioned in this register. Register means the government register.
Exactly.
There, no, and holds a document, and this is to be supplemented by holding a document for that land under the possession.
But that document
This
we
has to
have,
be-
my lord. Those documents we have, my lord.
Where is that?
That those documents, my lord, they have issued the certificate also, my lord. Those certificates we have, my lord. Where? We have few of the certificates we have annexed, my lord.
One certificate will do.
Yes, yes, my lord. My lord, I don't know where.
No, not in this one.
From the in this one also we have those certificates.
One certificate you have not taken here.
Page number 169, my lord, may kindly have a look, my lord. Settlement of land in Kaki, so and so under Tongia system. Now, this is a letter issued by to the deputy commissioner.
That I have read it. My question is here.
My
The 169 is by a letter by the joint secretary to the government of Assam,
Government of Assam.
to the deputy commissioner Noga.
My
Now, my question is out here, this is the document which has been said that you kindly give them and include them as Tongia. Now, the basic idea of a Tongia system is that these persons will be used for the purpose of here. What you call for the betterment of the forest. But what they are, you see, giving it a complete misuse of the very Tongia concept.
lord,
You see, these people, what do they say? These 700 families from this particular reserve forest have been evicted. So kindly do one thing, put them out here in this particular forest as a Tongia.
to cultivate or for the welfare of the forest.
No, not for that purpose. And you see, I directed to clarify that about 700 evicted families from so and so who have no place to go may be given temporary shelter under Tongia system.
Fine.
But this goes very much against the way concept.
Yes, my lord, the Tongias.
Now,
itself-
what are these documents? Can you come to page 168?
It is a local multi-state village is situated.
These won't be, those are nothing, but this has nothing to do that you are Tongia.
Admittedly,
167.
look, admittedly, this is also a certificate issued by the Milot Town Panchayat. That this is an area is a forest village, Milot Lutumari Amdobi forest village. The said village is situated within the.
How are you correlating with the petitions?
Because Milot, the area wherein we are residing, Milot, at this moment is also, they have declared as a Milot Lutumari Amdobi forest village, the area wherein we are being residing.
But you have to have a certificate.
No, we have that certificate.
Where is that?
Milot, those documents the state is Milot maintaining. State is maintaining the register as well as those certificates are also within their possession.
No, you have to
Why
have from 1970
Why
onwards,
not?
you don't have the certificate.
No, we have.
This is wrong, man, because not correct. My lord. Paragraph 9 of my initial affidavit in this case, item 7. Paragraph 9, I have specifically mentioned in this case. The affidavit starts at page 314. Paragraph 9, my lord. As regards the claim of the petitioners declaring the area in question as contract village, it is stated that Forest Department has not created any forest village in Utumai Reserve Forest. Hence, no Gauhati register exists for a said reserve. The question of we holding some certificate doesn't arise. There is no forest village declared at Utumai.
My lord, I am troubling my lordship with item number 10, my lord, of the same area, my
In
lord.
this affidavit, my lord, at paragraph, they've given a picture of what was the Tangia, my lord. Paragraph 8. This Tongia, my lord, you kindly picture one thing. This Tongia arrangement continued prior to 1980, my lord. After 1980 Forest Conservation Act, even if somebody has issued an order, it is not in conformity with Forest Conservation Act.
No, obviously, after that,
Yes.
cannot.
So now, my lord,
But the question is, there has to be a creation of right prior to 1980.
yes. Yes, merely because someone was
Merely by asking this person concerned, because otherwise also, if you see section. Problem arises here now, this section 31.
Yes.
Of which stipulates that there has to be a settlement of rights in terms of chapter 2.
Yes.
Now, chapters 2 says specific declarations will be.
Yes.
See, chapter 2, how is it possible, how a person can be given?
Yes.
Acquisition of rights has to be power to revise the arrangement of the so and so, power to hear acquisition of rights.
Yes.
No right of any description shall be acquired in or over the reserve forest except by succession or under grant or contract in writing made by or with the previous sanction of the state government.
Yes.
Or some person on whom such right or the power to create such right
Was
vested when the notification under section 17 was published.
Yes.
Now, this right has to be created as on the date on which the
Yes.
forest village was
Yes.
made. The concept of creation of a right subsequent is foreign in chapter 2.
Agree. And my lord, in this particular case, the statement on oath, my lord, that there is no forest village ever notified inside Utumai.
What about the other two? They are. But
Only one, my lord. In item number 2, in Doyang and my lord, there are some forest village. But therein we have taken a plea, my lord, these petitioners are not found inside in the Jamamandi. They are claiming that they are residing in those forest villages, my lord. They are holding no document. We also don't have any record of indicating that petitioners are there. It is on oath, my lord, I have said it. There are only in item number 2, we have agreed that there are forest villages, but these petitioners are not relatable to those forest villages. They are having no document. In rest of the cases, there are no forest villages. So if you go to the Honorable Supreme Court's order, my lord, there has to be a Ramabandi, my lord, for it. In Utumai, my lord, there was no forest village ever notified under the regulation. The question of having Jamabandi doesn't have it.
in fact, the rules of 1930 seems to be not controlling some constitution.
In fact, well, the rules of 1930 cannot after. It's a pre-colonial rules. Those days, my lord, our rulers were more concerned with extracting forest produce, my lord, not to protect the forest. My lord. So 1930, that's a pre-constitution rule, my lord. Cannot survive. Neither 1980, neither 1980 nor 2006. My lord. If we see, my lord, 2006 Forest Rights Act, it's some amount of relaxation on the Forest Conservation Act. My lord. But subject to the conditions therein, my lord, those communities are to be specific, my lord. Middle tribe or forest village celebrate. Only exception to Forest Conservation Act is that, man.
No, because they either we they say that there has been historical injustice. Even in the year 1991, after the Forest Conservation Act came in 1980, 1991, there were certain steps being taken for granting certain benefits to those people who were there prior to 1980.
Yeah.
All these things were going on and nothing happened, and plus the parliament came up.
2006.
Did you only
After 1980 and 2006, man, of the arguments that are being raised, man, cannot survive, man. Cannot survive, man.
I mean, my argument is that whether we can be termed as an enforcer. We cannot be termed as an
Holding a, my lord, electricity certificate.
I am not on
Voter ID,
electricity
my lord.
certificate or voter ID, my lord. It is their conscious decision, my lord, that under the Tongia system, we have been allowed. The deputy commissioner, the government is writing letters, my lord. Now, my lord, my kindly appreciate, my lord, after so many years, my lord, I am very sorry, my lord, I am holding this certificate, which could not make a part of the records, my lord. Just for a moment, my lord. 5 copies are about.
These are petitioners here.
Yes, yes, my lord. We can identify the certificate to the petitioner, my lord, it's being. So therefore, my lord, my respectful submission before my lord is that the notice, if we go by the eviction notice, my lord, now they have make us at par with the encroachers, my lord, which is not at all correct, my lord.
What is this Sonia plantation?
My lord, what the purpose of our, my lord, allowing to reside there to plant some specific plants, my lord, that is called root seed cultivation, my lord, as I have gone through, my lord. Now that root seed may be, my lord, one kind of tree or something like that, maybe. I'm not very sure as regards the definition. But my lord, one thing is sure, my lord, that after the 1980 Conservation Act comes into, force, my lord, that the human habitation or the non-forest activity is very difficult. Now, whether, my lord, these people who has been consciously, my lord, allowed by the government under a rule created by them, my lord, no doubt, after the 1980 Act, my lord, that rule may not be, my lord, surviving anymore. Now, after utilizing, my lord, us, my lord, for the so many years, my lord, now they have said,
For the government.
my lord,
But you have to understand. Always feeling
that is that. Now, my lord, if now we are going to be evict from the said area, my lord, then they should make some alternate arrangement, my lord. Now, my lord, I kindly appreciate that as an employee, you employed us, allowed us to reside there, settle there. Now, suddenly you come up with a policy.
been allowed to reside there.
My lord,
People have been allowed to reside there for protecting the forest, and now there is no semblance of the forest of the heritage.
no, that is, my lord, now whether, my lord, where
What we have
now, my lord, now such a situation is also there, my lord. I have visited, my lord, in some of the areas wherein, my lord, from miles and kilometers, there is no any semblance of any forest area. Now, those areas originally were, my lord, forest or not, that picture is also not very clear, my lord. That original vegetation and what was the nature of the forest, that is also not clear, whether it was originally a paddy field.
That is why, we are saying that it is their part to care for Colombia. Because the fact that Colombia will petition, who say that you have been asked to stay in the reserve forest. No, that's your case.
No,
The Colombia
my case
is
is
in the
that,
reserve forest. But if they are in the reserve forest, and there is no reserve forest, then what have you done? As regards the others, there is no reserve forest, there is no semblance of any reserve forest there. So how do you?
No, my,
reconcile the stand of rule?
no, Milord, I am not, I am only on the issue, Milord, that regarding the notice which they have issued. Both the people are being,
Not the question of the notification. How to do the reserve for the case where to clarify what type of action on the state. And in fact, they should stop every person who is there in the reserve for all the for to be in. That the forest, the unless here in this case, they say that in my reserve forest, they should be forest. Step is a step. So if there is no forest village, there cannot be a person who can reside there.
that's right.
And kind of the India within the boundary of the reserve forest, person can reside.
Now, Milord, here is the panchayat notification, Milord, which I have just brought into my lordship notice, Milord. In this petition also, Milord, we have annexed in page number 100 and starts from, Milord, page 155, Milord. No, 161, Milord.
So this will show that the government is exercising the powers under section 5 of the Assam Panchayat Act to declare certain areas to be areas for the purpose of the Panchayat Act.
And forest village has also been declared, Milord.
Forest villages as Panchayat.
Panchayat Act, Milord.
Now they say on one that there is no forest village.
It is the stand of the forest department
Therefore, they come up because the forest village is
by the forest.
can the government do so?
By the Panchayat Act, Milord.
So, but can they be creation of a forest village?
Now, Milord, why the
Actually, can they be creation of a forest village after the 1980 Act? Because even the governor cannot do so. A law made by the state. A law made by the central, it can be. By the central, it can be because there is no power from the central. Because what has happened is that the creation of the entire forest by the states, they were compelled to make this.
Milord, then, Milord, my one submission, Milord, is that as the panchayat has declared this as a forest village. Now, what is the source for them to declare this forest village? It is not, Milord, clear before my lordships also today, Milord. Now, if the forest department file an affidavit that for this source, we have taken the source from the forest department and declared this. Milord, then there can be some light can be.
I should be going, but that because the yes, exactly. Make it the governor will make it. By doing the notification. But in those notifications, we complete the 1980 Act. If it is within the point,
Within the reserve forest also, Milord, as the Panchayat Act says that the forest village key area, Milord, can also be included as a Panchayat area.
so provided there is an existence of a forest village prior to that.
That's why, Milord, this,
So
they are.
Become a forest village prior to that. Except the forest village who has been mentioned in that paragraph number 7 of that. So the proposal has to be taken in the context of section chapter 3 of the regulation of 1891. Which stipulates the constitution of forest village can only be made by the government by any the official result constituting any land and the disposal of the government as a village forest. So this power has to be exercised by the government, thereby declaring it to be a forest. Declaring as a panchayat village is different from declaring it as a forest.
After 1950 Act, my lord, that section 35 has also become redundant. Now there cannot be any forest.
As of now, they can.
After 1980, that provision to
Prior to that, if there was.
Yes.
There to be a forest village.
Yes.
After 1980, you cannot.
Some
say
of
that
this,
I may submit one thing, last one submission, my lord. Section 2, forest conservation, just to indicate that the concept purpose, my lord. Notwithstanding anything containing any other law for the time being in force in a state, no state government or other authority shall make except the prior provisions of non-forest activity. So, notwithstanding anything containing any other law for the time being in force in a state, so that will include the Assam Panchayat Act. But section 5 Assam Panchayat Act, if my lord includes an area which is a declared reserve forest, that will not be permissible.
Then, my lord, then chapter 9 is, my lord,
Not chapter 9. Chapter 9 is for local self-governance. Chapter 9 is for local self-governance. If it is in contravention with section 2, my lord,
You have a take out the.
Yes.
Yes. But being a panchayat does not mean you are right not
Yes.
to be evicted from a reserve point. But do not give your right to name the.
understand. Now, my lord, what the law says, my lord, we have to abide by the law. That would be. Now, my lord, these are the peoples, my lord. I am submitting only regard the Tangia people. My lord. These Tangia people are admittedly being allowed by the forest department with their conscious. That you stay here. The various communication, the various certificates speaks of the same. Now, my lord, as a one-time drive, treating us as also as an enforcer, my lord, we are now going to the pro. My lord, no doubt, my lord,
You may not be an enforcer, but the fact that the state wants the reserve forest to be clear. We can very well say.
that, my lord, we can be, my lord.
Because the moment you are remaining out there, if the area of a non-forest, meaning thereby the state is permitting a non-forest activity under its notice.
Look, that one submission, look, we are not using the area for the non-forest activity. That for the.
There's nothing, no forest only.
No, my lord, they can. No, my lord, as
See,
we,
my lord, Tongia was for my lord development of a forest. In the process, what they have done, they have resorted to all non-forest activity, and that entire tree cover is gone. My lord. Entire tree cover is gone.
That is not admitted.
There is no
submission, my lord.
no tree in that area. My lord.
No, no, tree, when from those trees are not available, it is not, my lord, proved yet.
There is no in this way, my lord. There will be no end to a dispute. My lord.
Oh, my lord, my submission.
No, my only thing is, I need to take care of the 1914. The these rules are, it has to be compared to the state. Yes. See, when you make the rules of 1914, rules are made on the 74E. 74E categorically starting cannot be compared to the state regulation. Regulation categorically mentions the principle of rights only to the extent permissible in the chapter 2. Chapter 2 says the rights which are said that only can
At
be
the time of
said
notification.
by the person who was there at the time when the notification was issued on the chapter 3, section
Yes.
7.
Exactly.
So therefore, with section 17's notification coming up in the year 1916, 1928, 1929, there's nothing unless those portions which have been given time in respect to those particular forests where you have find the land with my forest where 1200 villages have been built. So those will be reserved with a different thing. But otherwise, how do you can be reserved? Anyway,
Deeply. But in regarding Tongia, my lord, in most of my affidavits, I have given an edition how it came in.
this Congress system has been
Obliged.
hearing completed, that can be done to dispose of search and in the next week. This I'm doing it because that day what has happened, I got a contempt matter. In that contempt matter, the ground which was taken is, the judgment was reserved, but the interim order was not extended. And therefore, they handed it over. And the reason, and thereupon, yes, the fact is true. That you should have done it, although we never do it, but this time I have to.
There is an interim order. We always wait for an outcome. of the-
Understood, but there they give it, the railways give it, and contract done, contract completed.
Deeply. My lord.
Obliged, my lord, deeply obliged.
Yes, Mr. H. Guramai, what is your matter? Your issue is only to the effect as to whether the termination of the earlier contract for not servicing some installment would amount to can be a ground for rejection of your technical bid. That's a subsequent bidding process for the same fishery in question.
It is not there. Admittedly, it is not. It was not there, but one thing is that we issued the settlement order, but he surrendered it.
So if he surrendered it,
But that
so
clause
that
is
cannot
not
be
there.
a
But
ground.
one thing, not one rider is there. That, অন্যমতে মীন মহলৰ সুবিধা কাটি can this rider be included decision of the distributorship? অন্যহাতে মীন মহলৰ নিবিদাকাৰী নিৰ্বাচন মংগবৰ কৰ্তৃপক্ষ সম্পূৰ্ণ কৰ্তৃত্ব থাকিব। তো নিবিদাকাৰীয়ে যে মীন মহলৰ কৰ্তৃত্ব হ'ব তাৰ কোনো চৰ্ত থাকিব না। নিগম কৰ্তৃপক্ষৰ সিদ্ধান্ত চূড়ান্ত সিদ্ধান্ত হ'ব। Whether the decision which has taken in the interest of the corporation by the MD in the technical bit, we have rejected them in the technical bit. The amount which is that you are not supposed to take that. Yes, we have rejected them in a technical bit. So now if Procedural interferes, then we have to go for financial bid again.
He's okay.
He's okay. His bid has been open on them and because he's been out in the technical part. You said 2 bid system, not single bid system. No, initially it was single bid. Initially,
The movement, how many years you have been running?
my rejection is for find plus or adding the next question of some other regard whether I have a right now continue to be given the basic question mark. Because in my institution, I have also challenged the order of settlement given my number 6 mark. Now for which I have taken ground that the offered price given by minimum revenue fixed by the authorities for the concern, and my offer was 3 times more than the offer given by him. Now the tender notice says that if the authorities finds the technical feasibility are not perfect from all aspects, that the highest bidder has to be offered for settlement of the bill. Now the reasons for giving a settlement at such a low price to the private respondent, in fact, again, there is a doubt on my offer. They are giving 3 times more revenue. They have.
But why have you surrendered earlier?
I reason for surrender is not surrender. Actually, what my understand says, madam, I never surrendered. The problem was that the moment I was given the bill on the day after 2 months from just a few days, they came with a subsequent correction saying that the original revenue, the annual revenue, which was 15 lakhs, for the bill concern now has been reduced to 8 lakhs. So they have accepted my offer on 15 lakhs. The moment they reduce, they say that your amount that you have offered is 30% more than the current reduced amount. So you are liable to pay 11 lakhs more as per the tender documents. In spite of your security deposit, extra 11 lakhs you will pay within 7 days. My difficulty was, my lord, I was prepared for such an unprecedented thing to happen in just a few days of my settlement in given to.
Where you mentioned?
Yes, ma'am.
Which one?
And the Russian may come. To paragraph number 16 and 17. 17,
Which?
page number 27 of 5. Yes, my lord. Read petition number 1215.
Paragraph number?
16 it starts, my lord. May I just read, my lord? The petitioner herein prior to the current tender process was offered the settlement of the same bid by the AFTC in person to an earlier tender notice dated such and such prior to the initiation of the current tender. Petitioner being expiring and lordship can skip this part. Then this is the notice. 17 is important. Petitioner begs to state that in pursuant to the order dated 9/6/2022, that is order of my earlier settlement, petitioner made necessary arrangement to make deposits such as security deposit in respect of the fishery in question and in no time had deposited a total of 8 lakhs, such as 25% of revenue for the first and all other deposit, which was duly accepted. The said amount was deposited by 3 demand by so and so.
Wait. In such a security execution, you take the, in no time and have deposited the total amount of money. And the other deposit which was duly accepted by the AFC. The same amount was deposited by way of demand transfer. We mentioned that thereafter the execution without any prior information.
Suddenly, issue this letter addressed to the petitioner. 15 lakhs. In terms of a corrigendum, the petitioner was directed to make an additional deposit.
Was this corrigendum issued subsequently?
Yes, that is the point, my lord. After giving me the settlement, after making all this payment, you come with a fresh corrigendum saying that you need to pay additional 11 lakhs, that will be in 7 days, my lord.
Now, why the, you see, the earlier minimum revenue which was fixed was 15 lakhs 89,000
Yes, ma'am.
for 7 years.
For 7 years. This is annual. It is annual
No, 15 lakhs 89,000 was for 7 years.
for 1 year, madam.
Then it was changed and reduced to 8 lakhs.
Exactly.
Now, if it is reduced to 8 lakhs, how does the question of payment of additional deposit increase?
Yes, there is a cap, madam. My offered value for the fishery in question was definitely more than 15 lakhs because I would not have been given the settlement. So when I have offered 15 lakhs, more than 15 lakhs, so what their term says that if your offered value is 15 lakhs and it is, then they subsequently reduce it to 8 lakhs. The minimum value was reduced to 8 lakhs, my lord. So when minimum value was reduced to 8 lakhs, they never gave me the concession that 15 lakhs that you have offered more than 15 lakhs will be relaxed to give maybe 10 lakhs. They never give. What they did, my lord, of these 8 lakhs, now they are saying that since it is 30% more, my offered value is 30% more than this 8 lakhs. My lord, I'll come to that particular provision, my lord, according to which if my offered value is more than 30% of the minimum revenue fixed, I am required to pay additional bank guarantee. The reason being, I may not be able to continue with the running of the fisheries at such huge amount, that is 15 lakhs and above. So they take a security for me by additional bank guarantee.
So, how do you reduce the minimum, the change the reduce to 8 lakhs?
Even that is,
Show me the provision, how it is
yes,
possible.
yes, sir. Kindly note, let me come to the new provision at page number 66, my lord. 66.
Yes.
But the second 12.2 condition is very important. If in terms of clause 5 of the tender document, if the quoted price of the particular min mohol is 30% above the fixed price, bank guarantees of fixed deposits will have to be submitted for the excess amount, my lord. If necessary, the selected moholder to be
Okay,
found.
so therefore, what happened? They reduce it.
Yes, my lord. When
They reduce it to 8 lakhs.
8 lakh.
And therefore, it is in excess, your 13 lakhs is, 13 or 15 lakhs is in excess of 30%
Of the reduced amount.
of the reduced amount.
Exactly.
So of 8 lakh, of more than 30 lakh, 30%. So under such circumstances, you have been asked to submit a fixed deposit or bank guarantee.
Additional bank guarantee.
Yeah, to revalidate the bank guarantee. So they have to therefore, is out of 8 lakhs, you have quoted 15 lakhs. So for that, you have been asked to pay certain addition.
Yes.
Now this term was earlier not there.
This term, according to me, my lord, it was not there, although I have not challenged them. Although my cancellation in my previous on a tender process was not challenged.
No, I'm not asking whether this clause was there.
But this tender, we will be in a better position.
Earlier, whether this clause
Was there.
then why did you reduce the minimum amount?
Yes, but
Reduce the minimum because this touches on these reasons. You see, your
Yes.
very reason for rejecting
yes, it was a.
is, if it is also seen to be not in consonance.
Yes, Lord.
Therefore, and that being cannot be a reason as for the terms and conditions. Therefore, it gives the good right for the court to interfere.
Lordship, that may be true, Lordship, but here at that moment, at that point of time, I can't say. I've seen the last one. Bank guarantee is always there.
But here the amount was reduced.
No, my question is whether clause point 12.2 was there in the earlier.
Yes, sir. Yes.
Was there. But was there a reduction of the amount earlier? See, the bid value, the quoted price of the mean mahal is above the fixed price. Whether the fixed price was around 13 lakhs or 15 lakhs earlier. And
Madam, may I kindly come to my.
we come to annexure 8. With the,
Yes, madam.
but that earlier notice inviting tender is here, no? We are concerned with.
My lord, this is,
Here also
we are concerned with number 20, my lord, that is page 57.
Where is the annexure?
Page 57 is the current NIT inspection. It starts with page 60 onwards, my lord.
67.
understanding is that
16/12/2022.
This is the current one.
Current one.
No, I'm not on that, but you have mentioned it out here, this particular document. A copy of the order dated 9/6/2022. Where is that?
That is at page 109. 109.
Offer of settlement. Your financial bid for 7 years amounts to 2 and been accepted.
That is 1 crore 19 lakhs can be divided into 47. Then per year, average it to be 14 lakhs or 15 lakhs.
Per year, for deposit of 25% as transfer, you requested to the bank guarantee for the amount. If you paid to so and so. So you are ready to deposit.
no, but here later on he surrendered also. Whatever the reason later,
111.
My lord, page
He could not
111 is my rate I have given.
he could not.
First year, my lord, it is 17 lakhs. If your lordship sees, serial number 5,
17 lakhs.
17 lakhs was my offer. So thereafter, my lord, the other rates are given there. And then, my lord, may come to the cancellation order at page 115, my lord. Page 115 is the cancellation order, my lord. The order which is giving, not the cancellation order giving me a direction to deposit this additional bank guarantee. With reference to the subject matter, you are hereby informed that if offer of settlement was made to you on 9/6, my lord, just not later. It has been seen that in terms of the minimum revenue was fixed at 15 lakhs, but
So that corrigendum letter is
subsequent. Subsequent, my lord.
no. Corrigendum letter is 22/3/2022, prior to the issuance of the NIT to you. Huh?
My lord, yes,
Obviously, that is why I didn't understand that. You see, you got the offer of settlement on 9/6/2022.
9/6, my lord. Yes, my lord.
The corrigendum letter was on 22/3/2022.
Yes, my lord.
And
I-
you knew about it. Therefore, they sought for additional bank guarantee. Mr. Counsel.
No, my lord, the amount which I had offered, they have accepted it. No, my lord. I'll just beg to differ, my lord. One aspect is there.
No.
Because
This
this-
said subsequent.
No.
No, when did you submit your bid? Tell me.
Yeah, but this, my order of
Page 111, let us see, when did you submit your bid?
Yes, my lord.
Your bid dated, the bid will be NIT dated
109, my lord.
Bid dated,
109 is the order, my
when
lord.
did you submit the bid? Where?
109
you submit the bid. You submitted the bid after the corrigendum.
Of course, my lord.
So therefore you knew about it.
But the order that came to me, my lord, directly was on 17/8 at page 115. Your lordship may kindly see. Original was made, I'm not on that. My submission is, my lord, that on 17/8, after giving me the settlement, on 9/6, they came out with this letter on 17/8 by telling me that you need to pay additional bank guarantee of 11 lakhs because of the original which was issued and because of the amount.
Rightly so.
Amount which was reduced.
Rightly so.
Yes, ma'am. So
Look here, deduction was done prior to you submission of the bid.
Then they ought not to have taken my offer as 17 lakhs, Manoj. That is my point. Then if they are reducing it to 8 lakhs and I have offered 17 lakhs.
That is your lookout.
Yes, Manoj, I have given and then
No, you see, the thing is like this. The tender was issued on 14/3.
correct, Manoj.
Then on 22/3,
Take
the
it with the
addendum came. Thereupon you submitted your bid.
Yes.
And at the bid, you did not look into it that the reserve price was 9 lakhs, 8 lakhs.
8 lakhs.
So therefore,
I could have
now
quoted-
they applied 12.2.
Yes.
And therefore they say that you are to do it.
Yes.
So therefore, now you want to say that why should I do it? Therefore you will go.
I cancelled.
Please appear to be the reason.
Yes, Manoj. And it was cancelled to me subsequently. If you'll also kindly come back, I cancel it.
Then now what should we do?
My humble suggestion is that on 21/12/2022, they have cancelled. Kindly Lordship may come page 117 of this particular petition, 117. Yes, Lordship, I will read. So this is where they have cancelled my bid and my, this thing was over, Madam. I did not put to challenge this cancellation. I again took part in the new tender process, which was initiated just, my lord,
And
they
they
were
were no part.
the part. So the NIT was the new
But
NIT.
they have used it as a part.
They have used it as a tool to debar me from opening my technical,
Where is the reason?
opening my price paper. At page 117 is the order of cancellation and the new NIT.
NIT one, he was selected the computer for settlement, however, he did not execute the agreement and surrender the student to, hence he is found invalid for participation in the next.
So this is
What you are doing.
Manoj. I give it to you.
Oh, have you made it?
So the order with, by which he sent a technical bid was rejected. Now, properly reflected in the order that he was a defaulter, that was not properly reflected. But actually, he is a defaulter, though they have not recorded the statement that he is a defaulter. Subsequent fine, after he was offered the bill, ultimately bid was taken back from him by page 118. That is on 21/12/2020. He was offered and he has deposited money long back. After 4 months, he has returned the bill to the corporation. Below, near hole, Procedural file, page 118. উপরোক্ত বিষয়, he was a petitioner, Atul Chandra Burma. উপরোক্ত বিষয় গুৰি জিলাৰ গদাধৰ মলখন নিৰ্দেশ নমে ইমান তাৰিখৰ যোগে আপোনাৰ দিয়া পত্ৰখন বাতিল কৰিছে, সেয়েহে আপোনাৰ পৰা গদাধৰ দুখন দখল সত্ৰ নিগমৰ দিনলৈ ঘূৰাই লোৱা হ'ল। So he became defaulter, he has accepted the offer.
The thing is this. We have to decide on the particular diction of the people of the ground. It is very,
Look, I understand.
now the reason is not there.
Vision is not properly explained.
So therefore, there is no other way to say, we put it back when the age is there.
So the AFT has not properly explained it. And he has surrendered ultimately, Lordship will find it.
Also, obviously, the question has to go through a question.
Lordship, I have,
In the smile of the petition.
Lordship, I have invested money in the bill as per procedure. And I am running the bill for last 3 years. Good. My money is like,
This is a matter of the man. And again, see, the only way that. But the reason
reason is not proper. Reason is not proper.
So the reason for which we have rejected is the means after termination of him, they have blacklisted him. Now blacklisting has to be done by on the basis of an order. Thereby debarring him for participation, which has not been done. I think we have to.
And like this, Lordship can see page 68. The documents to be submitted by the petitioner when submitting the bill. You have to submit whether there is a use or not. Page 68. Certificate regarding use.
Understood, all these things are understood, but that is not the reason. How do we take it?
Lordship, that was not,
Emphatically, when the AFC is not supporting you,
that was not properly explained by the corporation.
AFC is not supporting you. So, I can't help it. We have to interfere with it. Because the reason is bad. When the reason is bad, the reason. We interfere with it. Also, I don't- I so far, I we give them the liberty either to open the financial page and use or they will go for question. Yeah, correct. That will be more. Because then the price will also go up. So we come out of it. No concern with the state giving. So that Mr. Sharma gets.
Only my only submission, only submission is that I am running the bid for last 3 years. And according to condition of the bill, I have to invest my money.
When you run the bill for the first year, it is always profit. Usually, in the remaining years, you pay more. You see, as per the act or the rules out there, you have to pay particular amount in the first year, the second year, it goes to the third year, it keeps on increasing. Now, when you are doing only the first 3 years, you are profitable. When you are doing the third, fourth, fifth, and sixth, and then at the end of the year, you have to pay much more.
But I have to invest. I have to invest. I have to give seats. For growing of the seats, I have to invest money. As per the corporation rule. And there is a period where I cannot fish. Up to July, I cannot. Up to July, up to the month of July, I cannot fish in the fishery. Everywhere.
We have to only look into the.
There are two cases. Petition number 315. 315.
What is that?
We have basically by way of winning the price. I was approach this board by finding the petition 315. That actually merged with the current.
But there was an order passed by this court that any
Yes.
they shall be
Update to our some of it. That is it. Some of it.
Yes. For this matter. Yes, you have submitted the indemnity.
Affidavit has been filed by reference number 6, not been served to us.
Huh?
No, I have not. I have not. Received. Today it was filed. I have not received.
What does the response number 6?
But since there is a conflicting.
This is actually a question. I say that they have mistaken. They mock. They have filed an affidavit in this case of mock. There are things that are important. One is on 18th of 2025, the technical bid was opened by them. Technical bid on 18th of 2025. 18th 12th 2025. The technical bid, there was a meeting, final meeting. And in that meeting, there were 7 bids. Out of 7 bids, 2 qualified responsible, rest non-responsible. By the time there was representation which was filed by 2 of the bidders, one is bidder and one is non-responsible. They filed a representation placed before the board. Now the board on 7 months 2026 has returned back to the GEC, the Technical Bid Evaluation Committee, because there is a circular issued by the board where delegation of power was given to the chief executive. And table 2, these are the committee constitutions who decide. And accordingly, that representation was sent by board to the technical administration committee, my lord, on 9/1/2026, they said, and they decided these two recommendations before by these Rana Prasad leaders to more what in turn is sent to us. And accordingly, it was assessed. It was assessed and it was found on 21/1/2026 that these two leaders, Rana Construction leaders, even the opportunity was given to them. They doesn't fulfill. And what is the step? What is the order that is, they say, maybe we have delegated the power, but we can exercise supervisory power. The ones who have delegated, can you exercise supervisory power? Number one. Number two, 7/1/2026, it is their particular recommendation which was filed by those two leaders. Now they send back to the BAC, who decides it. And what they said in their interim order, that how can you open the technical lead without the knowledge of the RO? And RO was a part of that particular technical committee which was formed. This is their case, my lord. Now, delegation of power has been given by them by their own affidavit. Your lordship, please find their own affidavit one. Delegated the power. And they said, no, we have the power. I think that's what we mean by delegation. Yes. I show you delegation of power by a circular. A delegator has delegated their power by virtue of a circular that has been issued by the. So what is the delegation? A delegation is given or we act as an agent of the principal, like a principal and agent. Principal agents. So then, I'm saying that the principal needs to control. My lord, I will show you. My lord, what is the step? What is the evidence they have taken that step? They have taken a statement that yes, we have delegated the power. In fact, we cannot decide the repetition. No, that repetition has been said forward. No. Where it mentioned. Yes, 333. 333 kind of thing. 333. No, where do they say in there? No, please take 333, my lord. Of 333. Otherwise, they could have decided. 333 of the evidence is there now. 333, 7th of January, 2026. This is by the regional officer, bought performance based. Please find enclosed representation received in this office through email in connection above mentioned project. Kindly examine the representation submitted bidder and place it before the bid evaluation committee for appropriate consideration. Till the disposal of representation, it is because a financial bid of the project may not be open. Now, please see, then you say that the authority concerned had rightly taken into consideration on the basis of this communication. Yes. Now, how would if he doesn't have the power? No, then how can he forward this representation and direct they don't open the financial bond? When the representation was filed, to the Workman, when the representation was filed to the Workman, what forwarded it to the BSc? Because that particular, please see, by please see 278, 278, 270. See, my lord, in view of above, it was decided to open the financial bid technically responsive on 7/1. Please see first, my lord. Yes. Meanwhile, representation received from technically non-responsive bidder, namely Matters and Rana Construction, requested reconsideration of the technical status. Further, Rana Construction engineers have also raised complaint against the technically responsive bidders so and so. After detailed discussion, the following decisions were taken. Rana Construction in the representation letter dated 6/1 raise objection regarding non-fulfillment of integrity pact in prescribed format, so and so. Upon examination, the bid evaluation committee observed that Rana Construction themselves had not mentioned name of the work. Similar minor error also observed in the submission. As integrity pact in the RFP is a draft and forms of contract agreement to be executed. Successful bidder, BEC decided to ignore such minor formalities which can be rectified at time of execution of contract agreement. Now, if your lordship looks into it, number 2, for other point raised by Rana Construction, again Sanjay Singh and UCS Construction, BEC decided to seek clarification to 2 bidders and decided to allow them 3 days time to clarify the stand from the date of issue of the letter from chairman, and decided that failing of submission of clarification within stipulated time will make them technically non-responsive. Further, BC decided not to accept any additional document with the clarification. Rana Construction in the representation letter 6/1/2020 have accepted. They have submitted invalid license due to human error, which BC decided not to accept. Hence, Rana Construction stands of technically non-responsive cannot be altered, and there is no point arising for seeking clarification regarding other grounds for disqualification. BC reviewed representation received from so and so, so and so. Now, my lord will kindly see. If your lordship looks into the next findings of meeting on 21/1/2026 at page 281. Kindly come to 287. 287. Yes. Wait a second. Can you come to serial number 8? Serial number 8, yes. Come here, 8. Upon receipt of representation initiated for examination at a ministry level, it was advised that the financial bills should not be acted upon pending examination. However, RO Gauhati informed on 4/2/2026, financial bill had been opened by state PWD on 3/2/2026 without prior knowledge of RO Gauhati despite pendency of examination. Now, please see the affidavit stand taken by the state.
No, not speak.
No. What
I'm asking you, my only question is
Yes,
whether RO was informed on 4/2/2020.
yes, it was informed.
Where is the comment?
Yes, I'm sure. My lord will kindly see. That was the only question, my lord. The paragraph of the affidavit filed by the government.
Right?
Please. 372, I think this man.
Where is the affidavit?
I go through the copies. 372, I put extra copy.
Where is the document of 4/2?
Three 372.
No, where is it? that this document I've seen, yes, because this is on 2-2. But here they say, people also see 280 that you see, however, the RO Gauhati informed on demand that the financial bids have been opened by the state on demand without prior knowledge of the RO, despite pendency of the examination at the ministry level. Yes. So whether the matter was pending before the ministry level.
RO, they said that people are not having the knowledge of the RO. That's what they are saying. How can you open the financial bill and the RO was not within this knowledge? And which clarify 288 TC, they mentioned it only 288. It is also noted that the financial bill was opened during pendency of examination at the ministry level and without prior knowledge of RO, Gauhati, and that both technical responsive bid were above the estimated cost. Now, I have to satisfy the lordship with one point that whether people within the knowledge of RO. And how can you financial be open without the knowledge of the RO? That's what the lordship are asking.
No, whether the matter was pending in the ministry level. Yes, it was pending.
We have taken that time. No, I will give an answer to immediate answer to what you are not to say. They directed us to consider the representation on 7/1 to examine on 7/1/2026. And we examined. RO was present. But please see the minutes for meeting, my lord. See the minutes for meeting where the RO was present. 278 kindly see, my lord. See, 9. The 278 final. 278, the RO was present. 278. At 280.
On third.
On 9/1/2026.
No, on third.
Third, prior on 3/2/2026.
Was it present? RO. No.
RO was present while deciding the evolution at the time of meeting mining, that technical evolution committee mining. And they were informed about it. Kindly see at page 278, my lord, first. Please see 278. 278 and see 280. 280 RO, result. Then 283. 280 kindly see, my lord. 280 and 280. While the decision, the repenting of the RO, what? Also got it. At page 280. Then also at 281. 283. And you see, my.
You do one thing. You give the contract and let them go ahead. You don't become you are the disbursing authority, no? You don't do anything. Let them do. Let the state PWD give it to him. You say that we have nothing to. Let us see what happens. What you are submitting out here, Mr. Das, you see, here whether only one thing has to be looked into, whether the matter was pending before the ministry level.
Lord, what has not been pointed out is page 275. Who's page 275? That was the first minutes of meeting. Lord. And page 276.
Yes.
At the bottom, my lord, a representative of the RO Gauhati was present in the meeting and opined that in case of the bidder, these Messrs. Sanjay Kumar Singh, Rana Construction, and Engineering, there were certain discrepancies in the documents submitted with
bank guarantee in POA, UCN construction, annual turnover certificate,
May take the
validity of labor license.
requesting for clarification from the bidder in order to complete participation in the tender.
Yes.
The chairman find that since the discrepancies in document in the solicitor are minor only, and hence were considered technically responsive as per the ministry circular. However, in case of Rana construction, as per the year, the labor license is found to be clearly invalid, and there is a mismatch between the invent so and so, hence the addition of where stocks put point. In view of that, the bid evaluation committee finalized the names of the technically responsible.
Now, this 1812 minutes was followed by the letter. Now, that is on 7 January 2026 at page 333. It is in respect of that meeting, my lord, this communication was issued for examining the representations of the bidder. After that, my lord, other meetings were held, 9-1 and thereon. So immediately after the first meeting, my lord, there was a direction from the ministry, my lord, not to, my lord, open the financial book. Even then, my lord, the chairman, my lord, went ahead to open the financial books, my lord. That itself is a ground, my lord. That itself is a violation by the, my lord, authority concerned, on which the ministry has taken a call that to maintain transparency, my lord, we should follow this entire tender process.
Now, you are saying one thing in your order, that the matter was pending at the ministry's level. Where is the document to show that the matter was pending in the ministry?
I can produce the record, my lord.
We produce the
I'll produce the
document, just one page, just now, here's page 3 from page. What the condition serial number 2. What was the instruction? It's very categorical. In this regard, it is requested to kindly examine the representation submitted by the bidder and place the same before the bid evaluation committee. No, only thing, Mr. Naik, we have to see whether the matter was pending before the ministry. So instruction was not whether it was pending before the ministry or not. Instruction was it was dispose of the representation, then open the financial bill. Whether that was done or not, that was the instruction not of the ministry. Mr. Naik, one has to understand one thing. You are a beneficiary of what they are paying. Yes. You know, kindly see, first of all, you on your own have also taken an action by which you have cancelled the tender. If you are holding the brief for the response, that particular chief engineer of PWD, then you have to say that why have you issued this particular document? If the submission which have been made that the authorities were wrong in passing that order, then why on earth did you take up this action of issuance of this particular document on 9th of March 2026? Cancellation order issued by the State Security Department is only in consequential order. Understood. So therefore, you have to say that this action, this cancellation order, you withdraw the cancellation order. Please submission. Please don't take any. Keeping the gun on my shoulder. I'm saying that if this is case 330 is quite clear. Instruction was that you first dispose of the representation, then open the financial bill. Exactly, you have done that, Lord. It was not the instruction that the representations are pending before us, so don't take decision. When was the representation disposed of? The minus, there not. On 7 the 9-1. On 9-1 of 9. Where is the minus?
9-1, your lordship will finance page 278. And 21-1. That is 281.
If lordship comes to 20, just one line. 283. One line of the. In view of the bid evaluation committee of the technical. So how can you say that I was not aware that the bid evaluation? Because in front of him, this is the work. So he was a part of the deal. Yes. You produced the records to show that the matter was pending in the ministry level. In spite of this, were you informed about this particular document wherein your RO was very much present? Minutes of the technical bid evaluation held on 21/1/2026, page 281. 83 or 281. 83. The 283 is the order. Yes. The signing, but the document starts at 281.
Yes, correct. 281. Yes, they have signed it. I'll take, although there is a signature. But
You cannot say that when, although they say that the signature is go.
my lord, whether the representation was pending, that aspect, my lord.
The only thing is, the reason is this. First of all, you were informed on by a communication was issued that on 3rd it will be opened.
Yes.
On 3rd it was opened.
Ma'am.
You were obviously not present. The RO was not present. Maybe, but you have been informed.
No.
Did you receive that communication
That
of
is-
information?
That I will have to take instruction.
So that you find out.
Mm.
And secondly, whether you were informed about the 281 and what decision, what did the ministry do then by producing the records? Okay.
Mm.
And what about the service upon the other respondents? They are there. Rana and Midas completed. They are not appearing. You are appearing. Heard Mr. D. Das, the learned senior counsel, assisted by Mr. D.P. Bora. Mr. H. Gupta appears on behalf of the learned CGSC. And Mr. P. Nayak, the learned additional advocate general, Sam, who appears on behalf of the PWD department. Upon hearing the petition at length, it has been submitted by the learned. It appears from the submission so made by the learned counsel appearing on behalf of the petitioner, as well as the learned additional advocate general, that the representative of the regional office MOT were duly informed about the decision of the decision of the technical evaluation pursuant to the communication dated 7/1/2026 issued by the executive engineer for regional office Gauhati to the chief engineer to the respondent number 6. The same aspect is apparent from a perusal of the minutes of the technical bid meeting evaluation held on 21/1/2026. Further to that, a perusal of the affidavit which have been filed by the respondent number 6 shows that on 2/2/2026, the regional officer MOT was sent a communication intimating that the financial bid would be opened on 3/2/2026 at 2:30 p.m. The learned senior counsel appearing on behalf of the petitioner therefore submitted that the very basis on which the impugned decision which was taken on 3/3/2026 appears to be without materials and a complete abuse of the process, inasmuch as the representative of the regional office were duly informed about, was duly present on the date on which the representations were decided pursuant to the communication dated 7/1/2026. And further, the representative of the regional office Mort were duly informed on 2/2/2026 that on 3/2/2026, the financial evaluation would be open. Mr. H. Gupta, the learned counsel appearing, learned CGC, on the other hand, submitted that he would have to procure the records as to whether the representative of the regional office, Mort, was present in the financial evaluation which was carried out, inasmuch as he is a member of the committee so constituted. The learned counsel further submits that the matter was pending in the ministry level, as would be apparent from a perusal of the order dated 3/3/2026. In that regard, this court therefore directs that the records which led to the passing of the order dated 3/3/2026 by the respondent number. Who is the respondent? By the respondent number 3 be placed before this court on the next date. It is also submitted by Mr. D. Das, the learned senior counsel appearing on behalf of the petitioner, that in pursuance to the order passed by this court, the respondent number, the petitioner have already submitted the indemnity bond before the registry of this court on 24/4/2026. So taking into account the said, this court extends the interim order till the next date. To list this matter again on how much time? Twelve. 12th. On 12th of May 2026, at the top of the list. The registry shall bring on the affidavit filed by the respondent number 6 on report. Anyways, no more matters. All other matters then adjourned. When do you want, Mr. I. Chaudhary? Why, Mr. Sharma, why don't you file a review also as a matter of abundant caution? Take care of it. I thought about it during my lunch. I was just thinking the only way out is by way of a review. There's no way out. Not necessary that this is another SL. File it and say that as a matter of abundant caution, I file a review. And then we can take it up. This is the only way out. Otherwise, it becomes very difficult because you see, any law laid down by this court out there that because he's raising the point of maintainability. And understood, but he's taking up the point seriously. Then I have to decide that. The moment I decide this, and if I hold that it is permissible, it will open up floodgates in every case. That they may say, okay, this particular judge may not like this point, so let me take another point. We'll take this point later on. We'll have this matter whenever, Wealth I have to, it's okay. That is, he's top of the list. So at 2 p.m.
My friend has some difficulty on that your friend is 7.
Huh?
7.
No, you are doing 7. We have a difficulty because there will be a division bench on 14th. 14th.